Lordship, the file Lordship, the RBC, they are regarding eligibility worker. Anganwadi worker.
Worker.
Tomorrow, Lordship.
Anganwadi worker, what is that?
Appointment.
Appointment. Tomorrow.
That's the last item, Lordship.
No, not tomorrow. Have it on 16th?
Lordship, in your Lordship, the appointment will be out.
Appointment will be out, not before Independence Day.
Can you Lordship?
Monday,
Can you tomorrow?
not tomorrow. Tomorrow our board is overloaded. Unless it is a matter of life and death. Appointments we can always interfere. If we find. Will be on Monday. Yes. Monday.
May please your Lordship. May I take your Lordship in the next unlisted today.
Today,
Your Lordship, the matter relates to this final exam, your Lordship, starting from tomorrow. We came late, your Lordship, the blind man, your Lordship, and the PWB category, your Lordship. In fact, your Lordship, I will have to admit, your Lordship, in 2017, as prayer has been rejected by the register of the High Court, your Lordship. But ultimately, your Lordship, blind man fighting and lonely, that's your Lordship. There was some delay, your Lordship.
what was rejected?
Rejected he has secured the qualifying mark. Otherwise, he is not called for the university, the written examination, final examination. If it is not inconvenient for your Lordship.
No, but he's not called for.
On the ground that your Lordship, there is no provision for reservation under PWBD category, but advertisement specifically say.
You serve advance copies to the standing committee.
I will.
You serve advance copies. We'll see. Yes.
May which will function from my senior lawyer. I have mentioned item number 8 to 11. Madam, I kindly enter for a week.
Why?
Because in this case, your lordship in the last occasion has directed me to produce the records of the case lordship. It is not available.
We can't keep on adjourning these matters, Mr. Botaku.
Lordship,
Then it goes to the part 2 hearing list.
Lordship, that will your Lordship.
Then we can't help it. We issue rule and goes to the hearing.
I have not prayed for any.
He said you've given a consent.
Lordship, your Lordship, we have your Lordship repeatedly requested me, your Lordship.
We can't. No. See,
I am ready to do it.
we are. This is an admission hearing. Ordinarily, why should we go for an admission hearing in a matter which requires detailed hearing? No, take it up for hearing.
But
Let us do that.
in that case, your Lordship.
It will be listed. You are at liberty to make a mention before the court that this is a matter which requires ardent hearing. We will upgrade it and we'll hear it.
Your Lordship, your Lordship can give one time, your Lordship, on 22nd, your Lordship. I am ready, your Lordship, otherwise.
Your see the 22nd, the matters, the boards are all filled up till maybe 11th or 12th, 13th of September.
As per your Lordship convenience. Otherwise, I am ready, your Lordship. Even if your Lordship takes up today, I am ready to.
Then you wait, we'll see. You wait. Let the matter be called up. Yes.
I need to mention item number 72 of the part 2 list.
Part 2 list, you wait until the matters are called up. Why?
I got some personal difficulty matter.
All right, part 2, 72 will not be called up today.
After 20, but people have got no contact with the client, I have personal difficulty this week.
All right, this week will not call it up. Next week, after 16.
After 16. May please your problem. It's not to acting of 14 years. I am instructed to withdraw the petition.
14.
Yes, 1-4. Time for the petition.
Mr. A. Das, learned counsel to the petitioner submits on instructions that the petitioner does not wish to press the writ petition any further. Therefore, the petition, he seeks to withdraw the writ petition. Anyone for the respondent? Mr. C. S. Hazarika appears for the respondents. It does not object to the prayer made. Accordingly, writ petition stands dismissed. Interim order, if any, stands retained.
I did my 24. 24 months.
Next week. Who's for the APP? Where is the APP?
No,
You call the APP. Thereafter will take up. You inform the APP. Be available in the matter. Yes.
Late is your lordship, I beg to pay before asking for tomorrow lordship.
What urgency?
Lordship application or the promotion from a
Promotion is not urgency. It will come on its own. When have you filed it?
Lordship and the sum of our
New matter or old matter?
lordship.
New matter or old matter? Fresh matter?
Lordship, all matter.
Old matter can't be taken up to court.
Lordship, earlier the petition I have filed it for association, but the honorable court directed to file the petition individually.
Hmm.
So that's why some of the petition.
When was it filed?
Lordship,
When was the petition?
earlier the petition was filed in 2015, Lordship.
2015, so it will come for admission hearing.
No, Lordship, the petition was recently filed newly in this case, Lordship.
New case.
New case,
When did you file it?
like yesterday, Lordship.
Yesterday it will come on its own. Don't make a mention.
Lordship, kindly possible by tomorrow.
No.
Monday.
No. It will come on its own. It may be listed by tomorrow, it may be listed by Monday also, without mentioning. It will come.
Anyways,
I beg to mention for listing one review petition. 2021.
Review petition.
Yes,
Review of whose order? This one.
Honorable Justice, FCI Government.
Is it assigned to this bench?
Yes, bench chair.
You check up with the registry before whom the matter is assigned.
Bench chair.
You check up with the registry
Yes,
before whom the matter has been directed to be placed. If it is before this bench, it will come.
another is petition number not yes,
Listed for what?
admission.
Admission.
Yes.
Admission, give a date. Admission.
7th of September.
7th.
Yes, it will also. And recommend for listing and motion matter listing. Matter regarding this method target from 14 February lordship in the district of Nalbari lordship. A matter was filed 3/8/2012 lordship. Serial number has been completed lordship. So kindly this matter will.
Wednesday, 16th.
It will.
With the consent of the other side, may I please mention item number 18 by the daily list. Mr. P. Sinha will be arguing this particular matter, but unfortunately he is unwell today due to some IATC. Ask me to pay for some time.
At a request of Mr. So and so learned counsel mentioning on behalf of Mr. P. Sinha. Matter stands adjourned. It is submitted that the consent of the counsel for the respondents is also being obtained. List after 2 weeks.
I think I'm going to go now.
24, CD receipt.
I need some people.
All right, let it be on
Any treatment. No, it didn't.
25.
My understanding.
CD retained, CD receipt be retained, item number 24.
I'm not ready.
At the request of Mr. So and so, the counsel for the petitioner.
Daily list item number 1.
Yes, Mr. Kotogi. Your promotion has not been given with effect from 2005. Respondents have taken a stand that you are not covered by the ministerial rules. You are covered by the office rules.
Initially. Now, what is the manual? What's the kindly come to the clear?
There is no specific direction that you have to be promoted
Yes,
with effect from 2005.
What's the kindly come?
Page 32, 33.
Yes, 32 goes what way? The 31 minus, yes, discuss the law as well as the National Conference of Export Fund regarding paragraph 16, 17, and 18. Then in 21 years come to my life. after filing my lawsuit. You need a lot of it. Behind of only promotion revenue. The petitioner since is entering into submitted copies in the late 80s. It's clearly unreasonable and wholly unjustified. In fact, circumstances, notice of the read that the respondent should immediately take up the case of the petitioner for promotion to the post of office come in under the 91 rules. If necessary by antedating promotion from a date where petitioner could be eligible for promotion subject to the availability of vacancy to higher cadre of office come in. Once the exercise is complete, petitioner come within the ambit of 1967 rules in the lower rank of LIA, and will be entitled for a consideration of further promotion to a higher cadre of UDA subject to the fulfillment of eligibility. So from LDA, first of all, in a date manner, then after qualifying as LDA post for within the rules,
It is not antedating, it is a if necessary,
if
necessary.
because I was entitled promotion long back. Now, what they have happened, my lord, you must not kindly come to the next week. In terms of this order, my lord, I was proposal to the proposal directly to the senior assistant, not to UDA. That is a difficulty. UDA, my lord, that will occupy. That is order dated 13/7/2016.
Senior assistant is UDA.
UDA. So by putting that, we don't go through that normal rule, my lord. Because I'm not entitled for UDA, because I don't bullet for that cadre. Anyway, but they have appointed me directly to the UDA. Now what? Where I filed a writ petition, my lord, challenging that decision, my lord. That you will also find a case 36 in the order. 11/12/2018. That order you will also find. Then that disposal you will also find at page 38. According to the facts and circumstances, this court of the view that whether petition can be disposed of with the direction of the petition submit a detailed representation claiming promotion of the post of senior assistant from an earlier date, which shall be considered by the authority subject to availability of vacancy of such earlier date. This exercise will be undertaken by the respondent within a period of 2 months from date of receipt. So I filed an application. Then next page you will also page 39.
What was challenged in this?
Challenge my lord that because I was holding a senior assistant post from 2005. 1/5/2005. So I paid for promotion to that effect. So that is my
You were working in the post of LDA for some time. UDA.
Yes. Then I'm coming later on. I'm just creating the package.
No, while you were a copyist.
Yes, while I was working at copies, my lord. Since 2005, my lord, I was allowed to hold the post of UDA.
UDA. Then why have you challenged this?
No, but the challenge in the ground that I was entitled from one day, not from 11, from the date of order, man. That is 13 seconds. Ultimately, my lord, what they have done, my lord, that your ultimate can is a master pressure on 13/3/2019. That is your election 9.
Yes.
There you are also fine. This is the representation dated 7/2022, along with the order passed by this on court in submission must be to. And while order dated 7/2022, the High Court directed the respondent to remove the petitioner from an earlier date subject to availability of vacancy. In connection with this case, on compliance with the honorable court order dated 2022, earlier order passed by justice. The roster and register of the senior assistant amalgamation and establishment of the pre-commissioner Kamlo was thoroughly checked, and since there no post of senior assistant was lying vacant before the date of retirement of Abdul Aziz, so who retired from service superannuation on 39. So this post was taken in effect from 1/10/2015, and in compliance of the honorable court order, it is now was promoted to the post of from 1/10/2015. So earlier order was passed, that was of 2018. Subsequently, they have given it to 2015. Now this order by law, there was a contempt petition by law, earlier since pending by law. And this contempt petition by law, this honorable court by law, that you will also find at page 47. So coming that order of the ruling organization and deputy minister when they appear respondent. Second paragraph, petitioner submits that though the order was passed by the deputy commissioner is not an actual compliance of the order, also can comply. Nonetheless, court has an exercise of contempt petition may not enter into the legality and validity of the order dated 13. None counsel wishes to withdraw this contempt petition to deliver and file a fresh appropriate direction challenging the order dated 13/3/2009, any other factor. And is as well as other submitted petition is that from submission is not accepted in best category. So the liberty was given to challenge the order dated 13/3/2009. And accordingly, this petition was filed. Now, I give maybe the facts, my lord, that your lordship can come to page 54, my. There your lordship, the entire service career of the petitioner has been given in details. Because what is happened, the government of Assam wants to allow me to join for 1 page 2005. That is the your lordship can start page 54. Initially, the collector was appointed as a revenue office at a pay of 400 per month by this order 12, and regulated the appointment with a pay scale of 12 and posted a Romania revenue circle. Further, this office letter so is transferred collector to not revenue. Again, by so the collector as a revenue office after a few days was transferred to the Romania revenue cycle and it was entrusted with the now your lordship entrusted with the charge of senior assistant of Romania revenue circle with effect from 1/10/2005 due to the vacancy arises of retirement of Sri Kasinath Kolita on supervision of large and senior assistant of Romania revenue circle. So since 1/10/2005 I was holding the post of senior assistant of Romania revenue circle. The collector submitted a prayer to allow him to draw his salary since from senior assistant from the date of taking over charge with effect from 1/10/2005. The same was forwarded to the circle officer by the circle officer, Romania circle. And thereafter, this office has forwarded the proposal of the circle officer, Romania revenue circle, and checking instructions is allowing the collector to draw salary of senior assistant as paid for, but action could not be taken due to non-receipt of instruction from the government. In the meantime, the government, in the meantime, Saluda was transferred from the office of the SDOC and subdivision and subsequently paid 5% transferred in Fajul to the senior assistant. Placing at FPP office in the court of SDGF, Romania, high office number so and so. So I was transferred after putting more than about 8 years. On 2013, I was transferred to this as a senior assistant. On at Fajul Bhagwan, he was senior assistant at the office of the SDU, Romania. SDU was retired him from the FPP office so and so in the post of. Now, what has happened, my lord? There is another important factor. In 2013, my lord, when the respondents came to know,
He worked as an UDA under which cadre? Is it under the DC in 2005?
yes,
2005 you won, no?
yeah, 1 page now.
So you were a copyist. You were a copyist under which office?
The establishment of this deputy commissioner,
Deputy Governor. And you were allowed to work as a DC under
the senior system, Romania revenue service.
Romania Revenue Service.
Only service under deputy commissioner.
And then these two were merged.
Oh my God, no. They were done, but I was working there for last 8 years. Then I was transferred back brought to the APP office and Romania. From APP office, madam, I was there when they came to know that I filed a petition. Came in formal complaint. Then they directed me there that I should be transferred back to the private office. That you are working. There is a letter issued by the office that you are working with private. And then both of them.
Now,
What is your option finance? Page 27.
what is your basis for claiming that promotion with effect from January?
Because of basically that.
Whether you satisfy the criteria or not at that relevant point in time.
No, actually, what has happened because my condition is that there's a direction of the honorable to appoint me as the LDA from LDA to UDA. But that they have not taken the course to that action. That direction.
You did not challenge that order.
Which one?
Did you challenge that order?
Yes, it is subsequently.
Subsequent repetition did not say on that. Subsequent repetition.
Okay, so
directed you to file a representation.
that they without going to that, but they have said that we file a representation for because since I was working as a
You did not file an appeal against that.
because I actually contempt like mine because the direction of the honorable was to initially appoint me as a LDA and UDA. But nonetheless, but they have appointed me UDA now. from 2015 on. Now the government, the government also might. You are not to be fine. Joint secretary might.
So what is the significance of the direction? Of the first coordinate bench at page 33. Now, after your promotion to office come LDA,
Yes.
you will come within the ambit of 67 rules.
Yes.
Why?
Because copies are not held by these rules.
So where are these rules? Office rules?
Copy rules are these are at the time it was draft rules. It was a draft rule, but anyway the court has said that it's
Is it available here? Office rules.
copy rules are not available. The other rule was there.
So you were appointed as a office and you are governed by these rules. 91 initially.
Yes.
So your claim to promotion will be in respect of the cadre promotional revenues.
From copies to copies come again.
Now, under that rules. Under that rules. But you are allowed to work as an UDA under 67 rules.
Yes.
So you are now claiming that you should have been promoted under 67 rules.
Yeah, promoted here, because of it.
So we'll have to look into the 91 rules. Where is that 91 rules first?
That was a draft rule, man.
Please come, LDA. Thank you.
Because it is, when I said it was a draft rule.
It is not available anywhere. Maybe with the government.
Office. Yes. Thank you. It is called Assam District Copies Establishment Service Code 19.
Now, assuming you are given the seniority
Yes.
with effect from 2005.
Yes.
How many persons will be affected? There will be some persons affected in the gradation laws.
Because I was working there.
You were working there. Were you the only
I'm going to say
UDA?
anything, nothing more than that.
Were you the only UDA?
Yes, madam.
Because see, you want the benefit from 2005.
Yes, 1 10 2000.
So if you are given the benefit from 2005,
Yes.
ordinarily your position in the gradation list will change.
Yes.
So if it changes, there are persons who are senior to you, their positions will be rearranged.
Most of them are retired. Those persons already. Because
So essentially what you are asking is for the financial benefits.
I'm actually for pay, because I'm given pay for from 2015. 1 day 2015. Now I'm paying for 2005. That is the thing. Because I was working that way. Their case is that there was no vacancy. If there was no vacancy, but for 8 9 years I was working in that. How can they say there was no vacancy? Because the state government also wanted that I should be given that post. Given that benefit. That your lordship can kindly see the state government's later mind, then I told. That is page 56, man. Page 56 government.
Who is for the finance department?
Right, instructor, Lordship, here, since it's a promotional matter, Lordship, it is the establishment that has to satisfy the potency. And regarding the petitioner, we have.
Payment will have to be made pursuant to your sanction.
Yes, Lord, and regarding the petitioner, Lordship, we have not received any proposal from the Director Department.
Of course, you have not received. We are asking you.
Yes, sir.
His claim is from 2005.
Yes.
He's been promoted with effect from 2015. 15.
Another period.
So the proposals were never sent.
Lordship, we have not received any proposal, Lordship. That is why we cannot consider the case of the petitioner at the present time. The moment, Lordship.
Our government has, because actually the deputy commissioner is the operator to pass the order. And the government has, you are also analyzing case 56 matter. 56 is categorically stated matter. There was a vacant board of senior, that is paragraph 4 months. Case 56. Issued by the joint secretary to the revenue department, revenue and AMD department. That is done.
From the revenue department, we have not received any proposal, particular case for petitioner.
They cannot find that. Yes, this competent authority is the deputy.
Yes,
Is the appointing.
Who is for the deputy commissioner? Why don't you send this proposal?
because of the. Lordship, kindly, for a moment, my Lordship, can we make a petition, page 87 is the order of the Solabut Road. Amended petition 87, 11 portion 88. For finding, amended petition, may I read it, order dated 18 2015. On the paragraph 3, case of the petitioner is there in the year 1980, he was.
Yes.
The case of the paragraph 3, the case of the petitioner is there the year 1918, he was appointed as extra writer in the office of the sub-register Kanur Patwadi, now Metropolitan. After working as such for more than 6 years, petitioner was appointed as office and posted in the office of the sub-deputy collector Romia. Since then, petitioner is working as office, presently in the office of the number 5 sub-officer Romia faculty. This is a post order, and as per. And paragraph 17, as already noticed above, petitioner has fulfilled the eligibility criteria for promotion already from office to office term earlier. Long back, but has not received any consideration for such promotion. There was the order and our affidavit. Our affidavit has not accepted this contention, and rather they say that they never even transferred and appointed as an FDA and senior assistant. Lordship, kindly see our affidavit filed by the deputy commissioner.
You go through the order 32, 33. The specific direction of the court was to consider him for promotion
As per rules 91,
to the copist and LDA
FDA,
under so and so rules
91.
91.
Yeah.
But what you did was to promote him to UDA under 67 rules.
He was not promoted, madam.
Yeah.
Our affidavit also can see our affidavit.
Where is that order of promotion?
Because by the case, case 34.
This is the order promotion.
Case 34.
Next page, next page.
Next.
34. purpose of honorable court order dated 18/8/2012. This was to the versus to Assam and post board approval accorded by letter of 11/2016. This was to the revenue copies of revenue circle in favor of the second post of senior assistant of revenue circle. There are other counts into force who declare from the date of joining in the post of senior assistant. 2016 Deputy Commissioner Amalgamation. This mother is promotion order how they have made it mother.
You are asking us, Mr. Chutia,
Not asking you.
you are asking the court how this order was passed.
I am thinking that. So affidavit, our affidavit says, in different manner. What's a fairly, have a look at our affidavit, say.
If you are not briefed properly, you call your DC, get a briefing, we take up at 2 o'clock.
Today,
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 today. There is a specific direction of the court. Tuesday, you will alone have to come for hearing, we are not coming. To the court. We are coming to the court, but not for hearing. Monday, Mr. Kotori. Hmm? 16, we'll have it on 16. Mr. T. Chutia, learned counsel for the respondents, senior government advocate, submits that he would like to obtain instructions in respect of the order dated Article 9/2016 passed by the Deputy Commissioner Kamrup Lingao, promoting the petitioner to the vacant post of senior assistant Kayan Revenue Circle. When the order in pursuance to the order dated 18/8/2015. What is the date of the order? 2015, passed in WPC 137 of 2009. And also, why the claim of the petitioner for giving effect to the promotion with effect from 2010 has not been considered by the petitioner, by the respondent department as yet. Mr. P. Kotoki appears for the petitioner list on 16. 2005. List on 16.
Supplementarily, top of the list item number 33.
Yes, 33. You were there, you were there. What is the matter? Why was it fixed today?
No, sir, yesterday, the private respondent, yes, the private respondent.
Demonstrated, sorry, civil defense,
That he was.
wireless.
He was entered and then given seniority, so my learned senior.
Did you speak to the counsel for the respondent?
I looked at the, if I was, there was no phone number or anything, I could trace out anything, your phone number and all that also. Because the earlier matter, so their phone numbers, etc. were perhaps not required to be mentioned in the file. council saying convincing person of the day or something like that.
I think that's the council.
Yesterday also, I think it was given.
All right, we are passing it over timely. Respondent answers.
List, item number 2.
Any information, Mr. Hall?
Yes, ma'am, I have an instruction. That here, the service record is being constructed. Here is the repetitioner. From almost 2015 is retired on 2023 being absent. Because we have given all adjusted every leave in the book of leave file. But from 2016 to 22, 31/1/22, we retired as unauthorized action manner. So some missing BP is also there pending. I have to, if notices issued by letter, then I can at least file an affidavit, I can see otherwise reply. But I'm just placing this instruction matter that service book has been constructed. You think that is the final stage. The last page, serial number 32, madam. It's a report, madam, it's a report.
By order dated 12/6/2023. Since the learned counsels for the petitioners were not available before the court on that day as well as on earlier days, this court directed the Guwahati High Court Legal Services Committee to appoint an amicus curiae. Stop. Pursuant to this order, an amicus curiae was appointed by the legal aid service committee, legal service committee. However, the learned amicus has also remained absent before this court on the last 3 days. So, Mr. R. Thor, representing the PWD department, submits that
I will just tell the last page that 33, madam. The point number 33.
submits on instructions that the service book in respect of the petitioner are updated as per the Chief Engineer Buildings Order number so and so dated 31/7/2012. And however, it may take about a month's time for completion. Subject to pursuant to verification of all connected reports and connected reports. So, in that view of the matter stands adjourned for 2 weeks. And the High Court Legal Aid Service Committee is required to inquire from the amicus curiae appointed as to the reasons for her absence. And in the event she is unable to represent the petitioner, another amicus curiae may be appointed in place. We of this order will brought to the notice of the registrar division, at least after 3 weeks.
Any for admission item 3. But already matter of finding. I'm going to be attending. Let's work.
Removal from service already lodged.
We'll admit and fix it for hearing.
Readings complete lodging.
Readings complete, heard so and so, admit. Let matter be listed for hearing in the part list. Item number 4.
We do not see, nothing matter relates to appointment of conventional ground additional nothing. From application itself, no ability to file the
Also, one thing is there, fine, you know, so if you also is pleased to understand with you, that one thing that is that they have themselves filed an additional affidavit also based on the direction of the honorable court. And in that you also there, given a page number 2, paragraph number 3 of the additional affidavit also. There is only 9 number of grade 4 posts. And if you come to 0.45, 5% of 9.59 will be not even 0.5 year also.
Below 1.
Below. There must be at least 20.
But it is my information based on my report of RTI. Later government found.
What he's saying is, if it is 0.45%, below 0.5%, then how do you round it off to consider it to be one post? May not be one post. But in that case, you'll have to consider whether vacancies in respect of other departments are available.
That may be done, but this otherwise 2021 matter, we have also not filed an affidavit or it's subject to.
Where is the order? Your case has not been forwarded.
SLC rejected.
Where is that order of rejection?
Page 26.
26.
Another 8, page 26. The last paragraph, nothing. It is not exactly. The last paragraph, page 26. Then it is correct.
Yes.
Also considering that one of the working group, Treasury has been rejected due to non-availability of vacant post and his application has been sent. Therefore, for more than that's of more than 2 years left since the date of application. So that is not the application is required, but this year's time.
What's the name? Your how many petitioners are there?
One.
Number 1. What's your
Also considering that.
where is the DLC recommendation?
You see at page 19 and another 5.
DLC is not supposed to verify regarding the 5% quota.
That's it, Lordship. Otherwise, they have said this file, that is why presumably the honorable court has given an order to file, they are supposed to file an RTA and get the vacancy position as well. First, I think it was on 10/11/2020 or also that.
Then you file your affidavit. Instead of they file. Heard learned counsel for the parties, Mr. C. Hazarigal and government advocate will file the affidavit on behalf of the respondents, reflecting the vacancy position under the 5% quota, for to which the petitioner is staking his claim or be considered for completion. At least after 3 weeks. Copies have been served. Item number 5.
I think number 5 is also similar to professional appointment. The in order is page 24 and the relevant Derivative 325.
25. 25.
Yes, sir. The serial number is petition. And the ground of rejection is, they have remarked that could not be recommended at 5% of the cadre and surplus period for appointment. Okay. In this case also, it is not higher.
Same order. Mr. Chudia, same order. Huh?
Okay.
Item number 6.
The derivative which challenge the performance of positive minority. And last that your lordship was this form of the records.
But you are gone through the records. Is in fact his PT has already been over your lordship and he has been exonerated from all the charges.
Then
Nothing remains in the question. I've gone through the records.
has he been communicated?
No, he is not complicated. He was recently done to lordship.
Will you show us that order? See, Mr. Bormiya, they got scared of you. So you have been exonerated.
I challenge two departmental for a sitting matter and it's a six and seven. But you can have a look out at the order. It would.
Which is that, where are you,
One matter page 7.
of the writ petition?
Yeah. So put reference letter matter 1141,
Page number
page number 17.
7,
17, one.
17.
It would actually for.
Where are the charges?
Nothing has been my lord, also kindly.
Reply
I
so
have
on
not
the,
served anything.
on the draft charges.
That also I have to say.
Then you said you had two proceedings.
It seems to be my lord for that.
Huh?
Because lordship firstly you will see at page 17 my lord.
Yes.
The reference date was 14/11/4/12.
Hmm.
Then I have approached my lord to the authority kindly supply me. So-called documents or anything my lord.
Hmm.
Number so and so till now, hence you are hereby I requested kindly to send me the letter in the present address.
Hmm.
Thereafter, my lord, I have been given another letter, my lord, he said, my lord, recording departmental inquiry. In respect of 11. Thereafter, my lord, again, my lord, page 21. Reference is taking my lord 11. Annex 1. Then, my lord, I have written a letter, my lord, 9/4/19, my lord, page 22. Then, my lord, I have issued the another show issued, my lord, lordship will see the memo number and annexure 1 memo number.
Where is the memo number? Annexure 6.
Annexes on the top, my.
FRE.
FRE 115/207 DP 1/19. Then annexure 1 lordship will see 1157.
Same.
It is no, my lord.
So is the part number different? Otherwise everything is.
Same. FRE 11/15/2017.
Date, my lord.
Huh?
Date kindly.
This is part.
That is the 19 April.
This is
And
part and
annexure
the
1
other is part 1.
Lordship
Part 1.
lordship will be clear, my lord.
Hmm.
No post notice date, my lord, 11/4. Then, my lord, 19/4. Two things cannot be, my lord.
What 11/4?
The annexure 1 is the 11/4.
Hmm.
And so it's.
There is something, you see the body, it's a show cause notice on draft charges.
I have not been supplied with any.
And his main prayer was that this 1941 plus issued to.
So the charges which are against you, misappropriation of money, 40,000. And submission of false accounts. So there you have been held to be not proved.
If it is not proved, my lord, if the should have closed, then.
Has it been accepted by the committee, disciplinary authority? No.
Most probably yes, Your Lordship.
What
Because
most probably?
once it's done, it's recently done, Your Lordship. I guess in the month of January, it has been done.
Huh?
In fact, I like one, the whole details of the inquiry, Your Lordship.
Anyway, if the authority disagrees, then they'll have to direct again.
My lord, if
So far as this is concerned, it is held to be not proved.
Yes. His observation be recorded. What submission he has made, then of dispose of the matter, my lord. And that will transmit me the copy of the order.
Very well.
It will.
Our learned counsels for the parties, this petition has been filed by the petitioner. To challenge the disciplinary proceeding initiated against the petitioner. And the show cause notice is issued to the petitioner by the memo number so and so, that is 16/3/2019. And memo number so and so by the communication dated 19/10/2016, page 17, memo number 7. And the statement of allegations and the charges based on the statement of allegation communicated by memo number so and so dated 19th April 2012, page number 23. Stop. There were two charges framed against the petitioner, for which the inquiry committee was constituted. The charges are as under charge number 1, charge number 2, page number 23. So the petitioner thereafter filed his reply. Did you file your reply?
No,
We did not file your reply.
I asked for that.
Okay. The say communication with the charges enclose the list of exhibits and the witnesses. Stop. The petitioner, upon receipt of the same communication, requested the authority to furnish him with the documents on the basis of which the charges are being framed. Stop. It is the submission of the learned counsel to the petitioner that these documents were never supplied to him. Meanwhile, by order dated 4th of January 2019, the inquiry officer was appointed by the competent authority. Under such circumstances, the petitioner has approached the court, praying for setting aside and quashing of the charges drawn against him and the inquiry proceedings conducted on the ground that the documents which he wanted to verify and examine were not permitted to be done. And you did not appear.
Yes, entered court,
Huh?
here, there's a like, I have made a like mark, but we are here.
I went and submitted the application. Kindly give me all this.
Where is that flag mark? You submitted your defense. What are you saying?
From the inspection, what I am relying on.
You have not been instructed properly.
Page 22,
Huh?
Page 22 of my petition.
No, it is here. You have submitted your reply. You have submitted on 16/12/2022.
After filing it. After filing.
The learned counsel for the petitioner submits that he will not participate in the inquiry proceeding as the documents were never furnished before him. Upon directions to the learned standing counsel to obtain required instructions, the standing counsel has produced the relevant reports of the board. So, on due perusal of the board, it is found that the petitioner participated in the inquiry proceedings, submitted his written statement of defense, denying all the charges. So, the inquiry officer had also submitted the inquiry report. On the reports, it is seen that the inquiry was concluded and the charges, both the charges have been held to be not proved. The matter is before the disciplinary authority. Although a copy of the same has not yet been furnished. to the petitioner. So, having heard the learned counsels for the parties and from the perusal of the record which was produced before this court. This court is of the view that since the proceedings, since the charges have against the petitioner have been held to be not proof, the grievance of the petitioner appears to have been addressed by the department and no further cause is alive to pursue with the present petition. Stop. In the event the disciplinary authority decides not to accept the findings of the inquiry officer, then the proper procedure.
That observation may not be taken by not taken care of. That part.
All right. It is expected that a copy of the inquiry report will be furnished to the petitioner in due course to permit him to avail any remedy under any provision of provision required. In view of this observation, the petition 2640 so and so stands disposed of. Then in I 2313, in view of the order dated so and so, passed in WPC so and so, disposing of the heated petition, I civil stands dismissed as not raised. Close. Close then, you want disposed of, close and disposed of. I see.
All right. Item number 7.
That is the worst. I got the petition of the Supreme Lordship is the widow of the incumbent by the who died by the people of the case by accident. Here case is that by the he was placed under suspension by the that your lordship would see at page 36.
This is filed by the wife.
What? The wife of the incumbent, who was my lord, assistant general manager. At even point of time he was working. Assistant manager. Case 36 is the suspension order. He was placed under suspension.
Yes, there.
Then, my lord, they have submitted a short calls, my lord, at case 37. To which I have replied, my lord. I have replied, my lord. Thereafter, my lord, they have issued another letter at case 52. Then, my lord, and departmental inquiry was conducted. Accordingly, my lord, I asked for some document that your lordship will see page 100. Page, lordship has still page 100. I prayed for some documents. Prayer for supplying of the document, bearing number, serial number, so and so, so and so. So and so, with due respect, as the Vacancy the general chief officer, the departmental inquiry proceeding facts number, so and so, was there. In original, I asked for several documents that has not been given. Thereafter, again, my at page 100, I asked for another some document.
101.
Like you.
101.
Yes, madam. Initially, was 98, 99, 98. Just immediately 98, 99.
Then,
Then, that has not been given. Then page 100, again I have asked. They have not given. Then, inquiry report submitted and I was placed, I dismissed from the service, my lord. You order at 121.
inquiry report. Where is the inquiry report?
Yes, ma'am.
Submitted.
Yes.
Served up to you.
Copy of the written argument, copy of the communication, copy of the inquiry report, page 7. 72 to 8.
Yes.
So that I have given my lord, since my lord document was not supplied after me, my lord, even though my lord I have given my argument, but ultimately I was placed, my lord, without considering my document, my lord, repeatedly I asked for submission of the document. Inquiry report, my lord. I made a representation also at 102 page on extra 30. Written submission, my lord. That, my lord, nothing has been considered accordingly, my lord. By duty in order, I was placed, my lord, dismissal from the service, my lord. Page 121. So may I read the small paragraph? Departmental inquiry was held to the extent of the charges paid against in the tax letter of the charge number so and so, observing that it is full of nature that the reasonable opportunity were given to you as the stage inquiry for taking proper defense, and you also participated in the inquiry. I have carefully perused the records, inquiry there to the proceeding evidence reduced, briefs of both sides, findings of the inquiry officer, and your submission thereon. I confirm with the findings of the inquiry officer and satisfied with the evidence recorded at the inquiry and come to the conclusion that all the charges leveled against you have been proved and started here down. After considering the facts and circumstances of the case, gravity of the proof misconduct, your past record, I expose you the under on the measure penalty petition 39.1 of Assam Gramin Vikas Bank 12 so 18 with immediate effect. Thereafter, my lord, I preferred an appeal to the chairman specific authority that under that was, my lord, not taken into account, my lord, kept pending. In the meantime, my lord, the husband of the petitioner met an accident and he died, my lord. is that certificate is 135. He died, my lord, or accident, my lord, or
87.
yes, my lord. He died, my lord. Thereafter, my lord, they have not initiated any action, my lord, against my appeal. I was compelled to issue a legal notice at page 136. 136. Then, my lord, after receiving the legal notice, my lord, without giving any justification, the past the appellate authority by page 138. That is the last page of the appellate authority. In this regard, we have to inform you that aforementioned appeal petition number so and so, somewhat so and so, the charge affidavit so and so, authority of the bank receiving punishment under issue so and so general accordingly after careful consideration records of the inquiry and evidence reviewed by the considering the circumstances with the appellate authority and that point petition upholding the decision. Now the pushing down my is not my I made in several requests to them. Two occasions I made in request to supply me certain documents of the pertaining to my inquiry. That has not been supplied. Without supplying me, my lord, they have acted upon the inquiry.
But you participated in the
Yes,
inquiry, you
I-
gave a reply.
Has not been given, my.
May not be, you should have raised this issue there.
My lord.
After everything is done,
My lord, I have written, my lord.
written is not enough. You have come before the court after everything is done.
My
You
lord,
participated.
I have
witnesses
participated.
examined.
I asked for the document.
You may have asked for the document, not having supplied you a remedy to come before this court or any other authority. You did not. You did not come.
Even though my lord, for the principle, my lord, now my lord, I am with you, my lord. I am the widow. I lost my husband, my lord, in accident, my. lord.
Yes, Mr.
And
Also-
another one more thing, my lord.
Sorry,
Can we
sorry.
have a look at
Sorry,
page
yes.
60, my lord?
Yes,
That 60 last paragraph, my lord, it is the part of the allegations, my lord, page 60. Last line, my lord.
Hmm.
Last line, having done so, you were grossly violated regulation 18 and 20 of Assam Gramin Vikas Bank Officer Employee Service Amended Rules 2018, which attracts the penalty under so and so of the regulation.
You are reading from page
Page 60, my lord.
60.
It is a part of. Article of charges. Page 60. These are the stuff. But penalty has been given by the misconduct. And now what should we see what is 18 about?
What is?
What is the 18 about of the regulation? As page 60, last line, my lord. Last line, my lord.
18 and 20.
18 and 20. What is the 18, my lord? If your lordship perfectly I'll read or I can split off.
Better to supply if you have.
Lordship, I got it. I have yellow mark, my lord. 18 and 20. And now, my lord, penalty has been given, major penalty, my lord. Dismissal from service. That provision is also there, man. Other moves. And since, my lord, I lost my husband, at least some monetary benefit, my lord.
Where are the punishments?
39.1. Lordship, it is there, my lord. I have postponed it back one.
Now, you are challenging the proceedings,
My lord, I am challenging, my lord, both include.
or is it a case of merely harsh punishments?
Arts also, my lord, and enter both the order, my lord, I made a categorical prayer in my petition, my lord, because. Appeal also, my lord, that is not.
Yes.
Prayer portion, worship, will see page 31, my lord. I asked for the inclusion order. And B, I asked for, my lord, if the appellate order, my lord. And C, my lord, shall not be responded to the office of entire influence department. What is needed from sir? And seeking for D, my lord, authority for page 32. Providing all the service benefit to the husband of the petitioner from the date of suspension. So his restatement will be done, my lord, die.
Okay. Yes.
Now, lordship will have to see. For causing, my lord, as per the this inquiries conduct, my lord, the imping order reflects, my lord, because of the misconduct, my lord, not misapplication or anything else, my lord, or irregularity. Though they said, my lord, it is only proof misconduct. Whether misconduct, my lord,
Let us come to your charges.
not,
Charges.
yes.
Page number 52.
52 onwards. Article of charges, my lord, I'm reading operative part from the back. It is proposed to hold inquiry against the so and so number so and so. Is so and so the subsidiary and the implication of the misconduct. Misconduct in respect of which inquiry is proposed to be held that the retained below retains the statement of allegation. The article of charges are based on also instructed below. You are advised to submit the written statement of defense within 15 days from the date of the letter, failing which it will be presumed that you have no defense to that effect in the circumstances, and the bank shall be at liberty to proceed against you as per the rules in article of charges. During the tenure of your service, branch manager so from 16 to 19, you had sanctioned and disbursed altogether 217 numbers of loan, which is the period of 16 months. 16 months. 16 months from 27, 16 to 28, 11, altogether 4.15 crores, lakhs.
Now, why do you want to say that the inquiry is bad, or on what ground we are not re-appreciating the evidence?
In the actually, my lord, the departmental inquiry is done by only for the name sake. The moment we participate or we go, my lord, we ask for the document that is not being provided. And
But you participated. You participated.
Allegation is concerned, my lord. They are saying, my lord, misconduct. I did not verify the PAN card. These things. I am not the authority, my lord. It is the income tax authority. Our other officer is also there, my lord.
The first charge is that you changed the photographs. You
I cannot
fabricated
change.
the photograph. Loan account.
Against 117 number sanction, these are have bans on the committed gross. I have sanctioned that loan number. Then photographs were verified, authenticated by you. Clearly indicate that fictitious loans were created by you in a cumulative with the outsider bank at the defaulter. The following same group has on attract the loan documents through this name so and so. The fictitious loan accounts were created. Then they have given this file. Then lordship will turn to page 54. The loans were sanctioned as cash credit for the purpose of letter intending onward the lending among the group members. You had disbursed the loan amount transferring the.
See, you have to tell us why the inquiry is bad. Either your evidence was not allowed, or they have misappreciated they have not appreciated the evidence in the manner required. They violated the procedure. We are not going into the evidence piece by piece.
What happened, my lord, during penance of the case, person died. When I asked the widow, my lord, she cannot reply.
That is okay, but he filed the
That is the
information.
problem, my lord, created at this stage. And basing on my lord, all these documents, I have to estate before your lordship. And lordship will see from the record, man.
There
They
are
have not filed their affidavit also.
judgments of the apex court.
Yes, my lord, I'll come with that, man. So lordship, provide me some more time, my lord, any day, Tuesday, Thursday. I'll overcome, my lord. In the meantime, I'll also try to gather from our son whether any documents or any letter detailed to that, but only 2 documents I have been provided at page 101, my lord. That some documents have not been supplied.
Yes, Mr. Doctor, anything you'd like to submit?
The first point with my learned friend has argued that he is not being supplied with the documents. This is utterly, the incorrect statement in the sense. In the inquiry proceeding, he has verified the documents, he has given a certificate to that effect to the inquiry officer. Now, these gentlemen, during the course of inquiry, he did not challenge in the cross-examination part of our MWs are concerned. In every step, in all the question, he was asked whether he wanted to cross-examine. He said cross-examination declined, he didn't want to cross-examine. Then, he himself did not produce any evidence in the inquiry. What remains? It's not a appellate forum that the other side can say that these are the charges, these are the mistakes committed. Now, he did not even get any evidence. Now, what is the illegal minority lawsuit? Will be in a proceeding under 226. We'll see that whether any
Two things I'd like to just share with both councils. Come to page number 121.
is 121.
This is the order of dismissal by the disciplinary authority.
Here. This is dismissal order.
Dismissal order. So authority has considered on the inquiry day-to-day proceeding evidences, accused everything, then come to the second paragraph. Gravity of the proved misconduct. Firstly, what is that misconduct? Number one. And under the rules, what are the punishments prescribed for this misconduct? This is one area. The second is your past records. What is the indication of past records of the person concerned?
So far, the past record is concerned.
It's not available in the inquiry.
It's not necessary to go into.
No.
Because
That is what is evident here.
yes, that he has relied on that.
That he is relied on.
What happens?
Disciplinary authority is not mere authority, he has to apply his mind on the evidence.
So you know, it's very right. And you know, you find in all the, the punishment order, these people write in a routine manner, they used to use that word.
We are not supposed to accept that.
But your lordship will see, when the charges, if it is established, and on the basis of the inquiry in the inquiry proceeding, if it is established that the charges are, the misconduct is true, that is enough.
No, we are relying on the order of the disciplinary authority. That is what we are saying. The second is the appellate authority. Appellate authority has also passed a very cryptic order. Page 138.
Yes, that I have seen.
The appellate authority is also an authority to consider the appeals filed and pass necessary
He
orders.
has to be bearing the records of the very evidence, and considering the facts and community, the chair can appear before a group. And dispose of the appeal petition by upholding the decision in the case. Well, in fact, well, the appellate authority, they have to scrutinize and they have to give the speaking order.
Under the rules, there are several major punishments.
Here,
You have picked up the last one,
39, 1B,
1B,
5,
5.
dismissal with some warning.
There are 4 punishments.
Here.
Why the last one?
Last one, because we will also look at the charges. Well, it's very alarming.
No, it's not your satisfaction or my satisfaction. It is the satisfaction of the disciplinary authority. So where is that satisfaction arrived at, that this is the punishment?
You know, those things,
Why not
they-
compulsory retirement? Why not reduction to a lower grade?
Of course, there is no deal in that. But then.
Whether it is open for us to deal with it now.
Of course, no, that I cannot have any sort of. But then if you lost it, the inquiry proceeding is there, if you, I can provide you lost it. You lost it, will see. That what my friend is.
No, you-
Not the case about it.
We are not going into the inquiry proceedings, unless the counsel or the petitioner wants us to go through that particular evidence to say that this is the evidence and this is how it was appreciated. And therefore it is in conflict with the law or procedure.
Right.
He has not done that.
But my lord, in fact, he cannot take your lordship to those things. Because he has considered everything.
Hmm.
He did not cross-examine the management. witness. He
So
did not
you
use any evidence
So,
himself.
so. With regard to the acceptance of the inquiry report as well and subsequently the order passed by the appellate authority. We want you to address that this was done in terms of the procedure as well as the law. You are familiar with the law laid down by the apex court. Several judgments are there in this regard. So you address us on some other day. We want some time to. No partner. No partner. We are ready to finish the hearing today if you want.
Any day do that fast.
Any day, subject to, any day is good enough for us.
Lordship's convenient.
Yes, it is convenient from Monday to Friday, each of the days.
Let's take a fast.
Maybe later than you.
12 September.
12 September. Next week.
All right.
Hard learned councils for the parties, request of the councils for the parties. Matters that adjourned to 12 September, enabling them to complete their instructions and address the board.
Items 8 to 11.
I think that.
Yes, it's good to read. Yes, some adjournments.
As per last court order, you the procedure directed me to produce the inquiry report of the.
You are the agitators
No, sir.
and you are terminated. Rightly,
No, sir.
why were you agitating?
Like, all the vegetation, you have to long pendants of the.
What do you want the records?
Records for the inquiry report.
The inquiry report
Was not served on you.
of the year.
I have the report which where it has been stated that inquiry report were released after me. But right now I don't have the exact report also. The
Inquiry
one-
reports are not there.
Last time I ran it.
I have.
Inquiry report is not there.
Also in the file, it has been displayed.
So they must have served the original records without retaining any copy. Mr. S. Bothakur for the petitioner, Mr. Aram Das for the NC Hills Autonomous Council jointly makes a prayer. We are not made a prayer. Mr. So-and-so appeals for the petitioner, Mr. Aram Das for the NC Hills, who submits that records have been received. He requires some time to peruse the reports and verify. whether the inquiry report was submitted to the petitioners. How long will you take?
1 week.
1 week,
22nd.
not 22nd, it goes to 12th September. 12th September, yes.
Items 12 and 13.
These matters were the regional bench, is available.
What is this?
That reservation.
I mean, I am told that it was listed today,
It was in the list.
and the indication is that the judgment by Honorable Justice Chaudhary will be upheld. That is the understanding. But the written judgment has not come out. So you not think subject matter after some time.
It is submitted by both councils, Mr. S. for petition seniority, assisted by Mr. S. Das. Mr. I. Chaudhary, senior counsel for respondent, assisted by Mr. Vishwakaran, Mr. Hort for the government. Is submitted by the councils of the part that the issue is presently pending before the division bench and matter is likely to be heard.
Hearing is concluded.
Hearing, I am told.
Yes, and the hearing is concluded and the judgments are awaited. Therefore, the matter stands adjourned for 2 weeks.
When it is a will not subject we will not for listing of these matters again.
Readability.
No, these two before your launching. And if we are
25th,
25th of this month. Will not.
we are just taking up the matter. We did not pass any order. Did we pass?
So if your lordship puts up the matter on 25th.
Oh, that is what you want. Say that. 25th of. Yes, but that is a Friday. If you want a hearing, then the matter will have to be heard. Or you may not require a hearing. Is that your indication? In view of
Hearing
the,
will be required, because whichever way the judgment goes, hearing will be required.
they will not be covered by the division bench. Right?
In case of the judgment of the honorable single judge is upheld, so in that case, my case is covered. My case is even otherwise covered by the single judge's decision. Only thing is that if it is approved by the honorable division bench as well, then
Rule 4 is here. Clause 4.
But that is where I respectfully differ.
no, but
If clause 4 remains, the consequences will be in one direction. If it is obliterated, then it is in a different direction. So it will naturally depend on the judgment, but there are other perspectives.
so in that case, it can be put up on
31st.
28, 29. 29 tomorrow, something.
We'll have it on 25th if you want. We'll have it. We'll decide on a date.
There is your 25th honorable is adjusted.
Based on 25th. That's for by full Congress.
Items 15 to 17.
On appeals. The petitioner, Mr. T. Chutia, government and appeals for the respondents. Passed over.
Item number 19.
Ah, we are passing it over. Don't know after some time. If you are here, we take up. Otherwise, we don't. Not passing it over. You argue, you are there. You start your arguments. If you want,
They will pass it.
we passed it over, yes.
That is nicely.
Huh? See, Mr. Nair is the busiest council now, so. Because, you argue the matter if you want, you can begin. Okay, sir.
Will get the retirement benefit of 60 years or 65 years. Has been taken. Raise the age of all professors to the age of 65 years. And that benefit has been denied to the professor. Who is the professor of object order only on the ground, the extent has been filed, separate final benefit is there. The only grounds also not good, their appointment is taken up. It's the institute is not under control of the education department. It is under control of
Yes, Mr. Nair.
very reasonable. Okay. All of the things for this issue, whether it should be 65 being a professor, applying parity with other institutions, or it should be 60. Now, I was in a UGC controlled university. They advertised the post as associate professor. I came here. I was given the UGC scheme. The entire faculty member is governed by the UGC rules in this institution. This is the institution created by the government of Assam and ICSSR. Now, my lord will find the UGC has a career advancement scheme. Under that career advancement scheme, I was given promotions to the rank of professor.
While
After
you were working under the.
yeah, after coming back here,
Okay.
from associate professor, I became a professor. Now, when I became a professor, the post of professor, in the normal stream, became vacant. I applied for that. I became a normal professor, not the career advancement. In the regular line, I got professor. Now, being a professor,
In the career advancement, you became a professor or you got the scale of a professor?
a skill of a professor, they say it's deemed as a professor. Then in the normal line, I became. Now the cabinet takes a decision that 65 years would be the age of retirement for professors in education institution. One of the word used here is education institution. Now, once they say educational institution, then our board, governing body, started taking resolutions. But the government of Assam says that this is not under the education department, but under the transformation department. So it's not an educational institution, we will not get it.
Where is that order? Cabinet decision?
Cabinet decision and this. Have page 78.
Hmm.
Second line, right? It is decided to raise the age of retirement of all professors of education institutions, including medical colleges, to 55 years. Now, there are, my lord,
Do
resolutions.
you have the cabinet memorandum?
It's a note, I don't have the cabinet memorandum.
Here.
Here I am preparing for another 4, 5, 6, 7.
Who's appearing for the state? The cabinet memorandum we have. Where the decision has been.
That memorandum, yes, that will give an idea.
Because these are all communications. This is a communication.
Communication, but not taking an extract, that last line only, the earlier part is not here. If my friend can get that on record, maybe that will throw something.
Then I have to get a.
And Malad, we have made a categorical statement in our reply. Malad, there are 24 institutes run by this ICSSR all over the country, similar to us, Malad.
It's not only a cabinet memorandum, you may have to get the proposal. Which was
Proposals.
put before the cabinet.
All the
What was the
departments.
proposal? What were the views of the departments with respect to?
Lordship.
Cabinet proposal and approval.
Because where have they rejected your case?
Well, of the last part, page, 205.
205. What is this transformation and development department?
Man, it's the earlier planning department. Earlier planning. This is under that department, my lord, this institution.
This institution.
Institution, in collaboration with Indian Council for Social Science Research, which is under the, again, that institution is under the Ministry of Education, Government of India. And they have around 24 institutions. My lord, the institutions run directly by the.
You are on deputation or?
No, I'm a regular.
Regular.
If I was in my lord, that earlier institution in West Bengal, a university, well, then I would have been 65. I came here because they are following all UGC norms.
That 65 is UGC norm.
UGC.
UGC norms are applicable here also.
In here also, my lord, in that, if my lord looks it in that view of the matter, automatically it should come, my lord. And my lord, ICSR, there is a my lord, a catch here.
You get the UGC norms, we can decide the matter. They are available.
That UGC increasing to 60.
They are available in the
Yes.
communication detail, everything.
I can bring it, my lord. I can bring it.
Maybe the cabinet memorandum, I don't know whether it will be available in the.
Cabinet memorandum, it may very, my lord, will also have that, and in the meantime, I'll bring this also. And my lord, the interesting factor is, there are around 24 institutions run by this, in the similar manner by my lord ICSSR. And in all those 24 institutions, my lord, the age of retirement is either be of that a central government or of the state government, state universities. In those other institutions. Here, state university is 65. Professor, only for the rank of professor. The mistake the body was making was, it was changing the age of faculty to be 65. It cannot be. Lower than the post, lower than the professor, it's still 16. It's only for the rank of professor that the increase is to 65.
Associate professors?
16.
60.
And interestingly, my lord, those professors who have got it on CAS, career advancement scheme, they will also get 65.
You get it?
Lots. I also have that regulation.
The alternate counsels for the parties, this petition is filed by the petitioner, who is aggrieved by the denial of the enhanced age of retirement for professors, which is 65 years. Stop. Petitioner is a professor and is employed in the OKDISCD, page number 205. Omio Kumar Das, Institute of Social Change and Development. Stop. Mr. Nair, learned senior counsel appearing for the petitioner, submits that the decision to enhance the retirement age up to the age of 65 is a decision taken by the UGC. It is applicable to all educational institutions, including the present institute, to which the policies of UGC are applicable. Stop. That apart, the cabinet, the government of Assam, by way of a cabinet decision, has also decided to implement the UGC decision of enhancing the retirement age up to the age of 65 years. Stop. However, the prayer of the petitioner to given the benefit of the enhancement of retirement age was rejected by the impugned order dated 9th of August 2022. Stop. Here are Mr. C.S. Agarikal, learned counsel, appearing for the government. You have filed your affidavits, no?
All affidavits.
Yes.
Submits that the government, that the affidavits have been filed. Similar submission is made by Mr. Deena, learned counsel appearing in the respondents 345.
4, 5, 6 and 7.
4, 5, 6 and 7. You have filed your affidavit.
Yes, sir, we have filed our affidavit and in our affidavit say that the government of Assam has not considered this DISCB as an educational institute, but it is a research institute. And therefore they have not given the benefit and that connection also will find a connection here the next time.
Now, do you support the petitioner or
No,
you don't?
in that whatever the state decides, because here the stand of our side is not.
The learned counsel, Mr. Deenak submits that in the counter affidavit filed, it is averred that the government has not considered the DIS Institute as an educational institute, but rather as a research institute. So, there are to resolve this controversy, this court is of the view that the cabinet memorandum and if possible, the proposals placed before the cabinet may be placed before the court by the learned cabinet. So, learned counsel for the petitioner will also attempt to place the UGC norms and the decisions taken in respect of enhancement of the retirement age. Matter is deferred to enable the learned counsels to complete their instructions as directed. We can give you a short date on 12th September, even shorter,
This Monday.
29th,
29.
29th August. 29th.
Item number 20.
Yes.
Doctor, the petitioner is working as an Anganwadi worker, my lord, in Pahukata Anganwadi Center for more than 2.5 years, my lord. My lord, she had faced the interview, an oral interview. My lord, she was rejected on the ground of overage, my lord. Even though, my lord, she was working for 2.5 years, and even though she has faced an interview in eligible criteria, my lord, after that, she has been rejected on the ground of overage, my lord. My lord, how can she be rejected on the ground of overage? My lord, she is only overage and she already working for more than 2.5 years. She's a poor lady, my lord.
He is working as what?
My lord,
Anganwadi.
worker, my lord.
Anganwadi.
Yes, my lord.
And then she was rejected.
My lord, she has failed the interview, oral interview.
For what?
My lord, for the post of Anganwadi worker only, my lord.
Then how was she working?
My lord, she was working on a temporary basis, my lord. Even though she was.
What is the age fixed in the guidelines?
That is, my lord, 44 years.
Where is that?
They
Where are the guidelines?
They had placed the guidelines in their affidavit, my lord. That was 44 years. Affidavit or the government. And he is slightly overage, that is 44 years, 44 and 11 months.
Final was come to my actually final. Page number 43.
43. 43 something else.
Correct, no, my lord. My affidavit, my lord.
See, the running pages are mentioned in a sheet of paper on the cover of the file. You can ask your office to compare the running page and with the court file. Then it becomes easier. In the court file, here there is a sheet of paper where body of the petition, affidavit, running page, everything is indicated here. Yes. Your affidavit is filed by whom? Respondent 4.
Number 4.
Yes.
My lord, if I go to page 4. Running page 43.
In 43 different years, I don't know. There's an advertisement as annexure A.
That is.
Ah,
I will go to. Point number 2.
point number 2, maximum is 44 years.
There is pilot age varying from 18 to 44 years.
So you
Year
on
one, pilot,
the 1-1.
yes, pilot, year one, 122.
So 1-1-22, what was your age?
Minor chief,
4 years, 44 years,
Your age.
minor, let me come to my writ petition, minor, and actual 64, minor,
Age number?
64, minor.
Age number,
Page
yes.
number 64, minor.
Okay,
My writ petition, minor.
yes.
Since these are eligible candidates applied for the interview, Pakistan High School project, minor.
Hmm.
Her name is in number 1, serial number 1, minor, and it was written as eligible for interview, minor. If she is overage, minor, how can she be eligible for interview, minor?
But what is your age?
Minor, my age is 4 years, slightly overage, minor.
So you admit you're overage.
Minor, I admit that slightly overage, but minor, she has been working for 2.5 years, minor. She has already been working. And if they have conducted the interview earlier before, then she could not have come out with the overage limits, minor.
That is all
They have
right.
intentionally deprived her.
No, but you are not making the allegations that they waited for 2 years for you to become overage and then apply for the.
My thing is that she is a legal.
Mere
minor.
allegation will not help. You'll have to
Minor,
make the
but she is
statement.
already working and officially she has been said.
Maybe you are working, but you're overage. You admit you're overage. What is your right? What is your right? Tell me, what is your prayer? You want a direction to be appointed. When you know that the upper age limit is 44 years, when you also know that you have crossed 44 years.
My simple submission is only that, my lord, and so I am working.
Under what law you have your submission bereft of any legal proposition doesn't help. You make out a legal proposition that yes, this is how you acquire a right to come and claim that right before the court. You are working in a temporary post, which has now been converted into permanent by the process by which the advertisement was issued. You participated.
My lord, I have not been aware of the advertisement also, my lord.
But you participated.
My lord, I have just seen a simple notice, then I have participated, and they have said I am eligible.
How else are you going to be aware?
My lord, I have.
Even if you are aware, perhaps you can't take any steps to bring down your age. You will be whatever you are.
I don't understand, but my lord, the thing is that she has appeared in the video.
When was the advertisement? Advertisement dated? Advertisement dated
25/3/22.
25,
322, my lord.
and what is your date on 25/3/22? Calculate and tell us.
The 45 years.
Hmm?
And the 3 months after. So our parameter was 1/22 pilot. So another 2 months. The different months would be 45. We will go up by another 2 months. Something. In that case, if he was active pilot, he could have challenged the.
How many posts? How many posts? How many posts?
Post is one post. Then the private respondents would pass line. That is how she got pilot. What happened? You are behind. The she got. Page number 48 is the pilot final direct is. 48 is the.
A percentage mark was 0.8.
Hmm?
He has been rejected only on the ground of overage. No?
Which you are?
Madam, I appear for the this for the number 5. I was by my appointment was issued on 31st of October. I joined on 1st of November meeting, and after the interim order was passed by around 7th of December, my appointment was never put under challenge by law. This petition was filed, the interim order was passed on 7th of December, and there was an office order dated 13th of December, by which I was asked not to the meeting. Accordingly, I have not been forgiven my lord. My lord, here, I would also like to implore lordship certain aspects of the matter. If my lord comes to, the petitioner has stated that she has been working for 2 years, or rather more than 2 years, as an Anganwadi worker. If
Your
my-
appointment is stayed.
The appointment is not state, my lord.
Then
The interim order.
There is an interim order, madam.
appointment of respondent 5 shall remain stayed.
Yes,
Madam.
appointment was state, but my appointment was never under challenge. My lord is.
I'm asking you, your appointment, are you working? Who's working?
No one.
No one is working.
No one.
No one is working.
My lord, if my lord.
Have you filed a vacating petition?
My lord, I have filed, my lord, there is an order making the, my lord, recording my submission. That it will be treated as my counter evidence.
It will be treated as your,
As my counter evidence.
which one? Vacating petition?
Vacating. My lord, this is one vote, my lord. My lord, certain incorrect statements have been made, my lord, by the petitioner. But the petitioner says that she has been working for 2 years. She has annexed some monthly reports of the Anganwadi Center. The first portion of this report is an English translation from page 13 to 19, my lord. This is for the period of 1st January to 31st January 22. There she said that she is the Anganwadi worker. The vernacular version, my lord, is from page 20 to 27. Similarly, my lord, from page 28 to 29, this is for 1st of March to 31st of March. My lord, from 34 to 31 of the petition, 34 to 41 of the petition, my lord will kindly see the name of the Anganwadi. This is her document. At page 34, if my lord, this is the vernacular version of which no translation has been provided, my lord. The fourth row from bottom of the table, my lord. Third row, sorry. Third row, Anganwadi Kormi, Sri Mon Bora. The same section. This is also signed, the signature version we find at page 41.
You're referring to page number?
Page number 34 of the petition. Assamese version, no translation provided. 34, there's a monthly report for 1st September to 30th of September. The date is at page 41. At page 34, my lord, you kindly see the third row from the bottom. Anganwadi Kormi, Sri Mon Bora. Signature at page 41, my lord. Anganwadi Kormi Naam Mona Bora.
So what is the name of the petitioner?
Hiranya Devi Bora. Then, my lord, similarly, my lord, next page, page 42.
Do you have another name?
No, madam.
My lord, in fact, in the government's affidavit, in the CDPO's affidavit, they state, my lord, that she was never allowed to work. She simply signed those documents on her own.
Which documents?
Sorry,
Which document?
these monthly reports.
Mon
which
Bora.
was won.
Mona Bora.
No, madam, not Mona Bora. The petition.
Signature is Mona Bora.
Signature is Mona Bora of these. The
Who is Mona Bora or Mon
the
Bora?
actual Anganwadi worker. She was working up to 20th of December, on which date she died.
Oh,
She 20th of December 2021. So my lord, the contention of the petition.
so this, okay.
September and my lord, for the period of September and October 2021. Anganwadi workers' name is Mona Bora or Mon Bora, my lord, in essence. So the contention of the petitioner, my lord, is false. That she was working for years. The CDPO's affidavit is here, my lord, which was relied on by my learned friend, my lord. CDPO's affidavit, my lord, in paragraph 4, my lord, of the CDPO's affidavit.
Yes.
Paragraph 4, my lord. Reporting denies the statement in paragraph 2, answering this one, the that it is not correct that she was working as an Anganwadi worker at Kohubata, Anganwadi Center number 21. After all, nobody from the undersigned office had allowed her to work as Anganwadi worker in the same AW center, as because there was an existing Anganwadi worker, namely the Mona Bora, who was working and serving as Anganwadi worker till the death, that is up to 20th September 2021. The monthly report of Amalgamation Center was signed by herself according to her wish. And why the incident came to the notice of the central supervisor, warned her not to sign the monthly report. There was
Depends, and then how was she filling it up?
my lord, she, after the death of Monabora, she must have signed those documents.
No, must have been somebody must have permitted her to do so.
My lord, it is, my lord, that
Where
is.
is, do you have any order allowing you to work temporary? Then,
These are my signatures, my lord. My signatures are here. How can anybody go and sign their registered?
no, but how can anybody go and sign without any order of appointment? Temporary also. You must be allowed to work. No letter, no appointment, something has to be there. You can't be on verbal. And if you are on verbal, then you should have filed some application saying that your appointment order is not issued.
The petitioner has filed a reply to the significant affidavit. They are denial of the invitation of the. She has not, my submission, my lord, she has not come with clean hands.
Hmm?
She has not come with clean hands.
Yes, madam.
I don't know, kindly please, John, give me some time, I'll ask her to produce if she has any written document that she's been working. Or if she has any written document from the authority to work.
My lord, she has-
Once you have filed the petition, you have got an interim order.
She was already.
You are enjoying an interim order.
My lord, this
Then-
was already working, my lord. These are the signatures, my lord, she has. put
But
on
now you said you did not,
20, my lord.
right now you said you are not working, nobody is working.
My lord, means that she was not, and officially appointment was there, my lord.
Hmm.
That's why the interview has been conducted, even though she was working for 2.5 years, an interview was conducted after being her overage, my lord. This is the fact, my lord.
No, on the date when
If the interview has been held earlier before, she could have been got the.
no, what was your date on the date of the advertisement? What is your age?
That is my lord, I am already 44 years.
Then,
That is.
then, where is the question of interview being held earlier? You're already over age. You're already over age.
She was working for 2.5 years.
That is under now cloud in view of the allegations made. The department has filed an affidavit. Where is your reply to that?
Yes, my lord, reply.
I had to find a reply, my lord.
Where denies?
Why don't they come to page number 68, my lord?
Yes. No, your reply to para 4 of the affidavit. That is at page 67.
Applicant number 5 of the objection, my lord.
Hmm?
I will reply to respondent number 5, my lord. Affidavit.
Secretary, this is proposition, this is,
R4.
So I have denied everything in part.
for at least.
My lord, para 4 at page 67, my lord.
Yes, you have not
Let me
denied.
read the statement,
You have denied, but
my lord.
there is no agreement as to how you are allowed to work. This affidavit was filed on 12th April 23.
Summary. The earlier Amalgamation worker worked up to December 21. The advertisement was given in March 2025. There's no question of any delay in the advertisement as well. Only 2 months. 2 months.
The age, what is the state government relaxation today?
44 years.
That is also 44.
We feel before by the relaxation is 44.
What is your date of birth?
So CDQ representative age is on 1/152 is still different.
Hmm.
The age is. That's not possible. Annex B of CDQ, the R was senior number 1. Obviously, once you change, the definition exists already.
Page number,
Please, for please, then of the CDQ R4 certificate.
paragraph number, para 8, para 8. You provided some certificate, where is that? No, there is the age of the petitioner is so and so, as per the age certificate provided. Then what age certificate you have provided?
I have provided a copy of certificate, my lord.
Kindly come to para 8, page number, what is that, 34. You get your instructions if you want by tomorrow. Tomorrow. No, week's time. There's nothing here. We are only giving you an opportunity just to produce your age certificate.
I think you are better.
There's nothing here, madam. We are closing the hearing. We are actually closing the hearing. But we thought that certificate, if you want to rely on, you bring it on record. Or you produce it.
I have to complete it.
So Nogao is communicate her with the telephone
Kindly on the.
Monday. Monday. All right, Wednesday. At the request of current council for the petitioner, matter is sent adjourned Wednesday, till Wednesday, enabling her to produce the age certificate on the basis of which her candidature for Anganwadi worker in which center? Ohukata Anganwadi in the Nogam district was rejected on the ground that she was overaged beyond the upper age limit permitted, which is 44 years. Placed on Wednesday. 60.
Items 21 and 22.
Some interim order is there? No.
Madam, there are two cases, madam, actually. I am a statistical assistant, and in that hierarchy, madam, from the time before, madam, there is a post created for the statistical assistant in research.
All right. All right, hard so and so admit. We admit it. These are for admissions. You'll admit it.
We'll hear it from the admission screen.
No. Admit. We are giving liberty, once it gets listed, we are giving liberty to councils to make a mention if you think it is urgent. From the hearing list and we'll hear it. Because this admission hearing is not taking place because of one reason or the other. So if it requires hearing, we admit it.
It will require here.
Yes. Alright, any objections? No, urgency is there, but the councils are not available. We are available.
Have it for hearing next week, Thursday.
You can't hear all matters next week. Why can't we not take it up today? Where is Mr. Bora? So please tell him to be here. We'll take it up whenever he is here. Be available. We are not saying 2 o'clock. If he comes before 2 o'clock, we'll take it up. Mr. Das, you inform Mr. Das. Don't make him wait in the court. Huh?
Item number 23.
Everything medical issue, Mr. Ekpanik, couldn't talk to the court till now, but he'll be here at 2. So my lord, is present, maybe posted in 2 weeks. My lord can expect.
Affidavit file.
Airport private response number 7.
No, who's for the airport authority?
Yes, airport.
Who's for the airport authority? Where is Mr. Dubey? Where is Mr. Dubey?
I'll have to check.
Has he landed or is still airborne?
He was in the.
Landed.
Maybe my lord on legs in some other post.
You inform him.
My lord.
Yes. We are here as long as the list, as long as the board doesn't get over, we are here. Yes,
Where file 1 I also is.
bring it. Give a slip to the court master and bring it.
For orders, item 25.
Some IA is fine. This is for the IA. Mr. Goswami, it's for the IA.
Is below. What has happened is below. The petition concerns the process of promotion from junior assistant to senior. Now, by this time, the post of superintendent has become vacant. So, our contention is that the person who has been promoted with the vacancy, 2 vacancies offered earlier, is telling. He has been now again made a in charge superintendent. So the application, interim application will be filed in that they can continue, but don't confirm it because his promotion as senior assistant is under challenge. And we are watching this in stages of their contract. And therefore, that has to be cleared before he can be confirmed in that court. So he is still not confirmed in there is an interim order of 91,015. Want to confirm. Right, there is an order and told me that 9115.
Yes.
not to consult in your seniority. Therefore, this development has taken place because
You are for the,
I am for the petition.
you are for the petition.
So we are saying, so far as that part is concerned in interim application, that he has been now made in charge of superintendent. We say that when you become in charge superintendent, but you not so far. That is the prayer. In fact, we don't have your assistant also be very moderate page that we should be. Therefore, that matter is in question, you know. The process which is carrying is concerned, you know, the process of promotion from junior assistant to senior assistant. Which involves your two vacancies in the post of senior assistant. And our case is that these are, you know, the three petitioners belong to the three reserved categories, which is will not scheduled class, 7%.
You belong to reserve categories.
Yes, that's the claim 10%, that's the bills 5%, total 22%. That is the amendment under the 78 Reservation Act. As far as this category is concerned, because there is nobody belonging to these three categories. So when these two vacancies occur for senior assistant, and when the process was initiated, the petitioners plus the one Jackie Hansen and one Oru Kolika, approximately first year. So Jackie Hansen is still remains. They were promoted. The entire list, the basic melody, your lordship will see that there was no reserve category person in that list, in that category of and therefore we don't all right conferred under the law should have been considered. And I'll show your lordship the proceedings of that meeting. It doesn't even whisper, there is no period of whisper with regard to the reservation issue. Persons also were not qualified on the date they were promoted. That is another issue. So. The moment of the interim petition is for the second development, which is now taken place in the month of where the superintendent has retired, and therefore the
You submitted that one person has already expired,
one is the
so that post is also vacant now.
that is become the and somebody else was appointed.
Oh, somebody appointed.
Senior assistant, you know.
Somebody already appointed in the post.
And we are also from the judge, subsequent.
Subsequent. So now it's a question of seniority. It's
We
a,
are also, they were promoted in 2000. Yes, our promotion took place in May 2015. The main respondents were promoted on 28/10/2013, 2 years back. So what is under challenge is that 28/10/13.
so the government has filed their affidavits.
Government has filed their affidavit.
What is their stand?
Yes, you are looking at that, just have a look at the affidavit. proceedings in the next. Lecture 1 at page 6. This meeting took place on 21/10/13. At page 7, item 2, senior assistant headquarter level 2 posts. This is proceeding on question. The resultant vacancies of 2 posts of senior assistant have been caused by promotion of 3 anchor open senior assistant to the post of superintendent and the selection of 3 only for a senior assistant for promotion to the post of each. After verification of the gradation with requisite qualifications, ACR, the committee selected the following incumbents for promotion to the post of senior assistant. Jackie Rusi, junior assistant, Guru Punita, junior assistant. This is all so far as this is concerned. And therefore they were promoted as senior assistant on 28/10/2030. These are the check. You can the date of the meeting.
There will be a, what is that? These are the minutes,
That is the minute of the selection.
selection.
Yes.
And
Post.
before the minute,
Selection.
before the DPC.
Yes.
There is a what is- agenda,
Yes.
agenda for the meeting, which is normally circulated.
Yes.
Where all these issues with regard to
Normally. it should-
reservation and everything is done.
Normally it should be there.
Hmm.
The position with regard to reservation is required to be sent with.
So if it is, if the agenda reflects that there is no issue with reservation,
No,
Then-
in spite of that, they are signed the job of considering the promotion from junior assistant to senior. assistant. 5 names well. And if they have properly complied with the law, they should have sent the relevant details, including the reservation issue. But the proceedings will indicate that
whether it was
state of
considered or not considered.
they have not considered at all. That immediately affects the rights conferred under the 78 Act so far, we are concerned. Because the position on this date, when they were holding the meeting, 21/10/13, as far as this category is concerned, there was no reserve category candidate at all. Therefore, the required strength of 22% was not fulfilled. Therefore, they were considering the vacancy which was available in the post of senior assistant. 2 vacancies. On that, they should have considered the requirement of the law, namely whether there are reserved categories. You can't add general candidates to an already roster list, where all the candidates are without a single person of reserved category. So, can have a look at this.
You did not consider the reservation issue.
Nothing.
Para 7, para 7 of your affidavit,
Yeah.
page 62. We don't want, you tell us whether you are considered or not. It may, that therefore we don't want to see the record. You go through the record and tell us whether it was considered, not considered.
Nothing is recorded here, right?
Nothing is recorded and your paragraph at paragraph 7
My lord, I have six.
reflected on what basis the selection was made. Reservation was not perhaps considered. What is this roster register?
No, I'm only indicating,
Okay.
in case that meeting took place,
Ah.
what is the position, you know?
Where are the names?
Names are.
12 and 13.
Amin Bora was neither promoted as inspector, that is one vacancy. And he was, serial number 5 industry, it was reserved for FPP. He was working that force as an unreserved candidate. And, this will indicate, all the persons who were there. 14 of them, 13 of them, they are all unreserved. Now they have an obligation under the law to ensure that the required percentage of reserved category candidates are fulfilled. If you have in that selection process, 3 persons having that for these 2 vacancies, you are obliged to consider the reservation aspect, and they are entitled, 2 of these persons, they are entitled to get promoted. If your lordship just have a look at this, some directorate establishment maintained ministerial service rules and disciplinary.
Yes.
If I am just reading from your record only, I for the continuance of the board, we have further about.
Yes, Mr. Nair.
One of them, I don't say, so speaks for it. Another we not doing it. The minors and the provisions of demonstration. I don't have seen the management. Will have page 9.
Mr. Goswami is asking him.
Yes.
You'll continue with your arguments. Yes, yes.
I don't will have page 9.
Page
9.
9.
According to me, my lord, the cadre strength was 11, 13, my lord. And 11, all the 13 posts were filled up. As on that day. My lord will have page 9 of the academic of the, which my lord, senior has my lord referred to. Affidavit of the transport department. Deputy Director, item. Raj Hussain.
Which one came, sir? That is part of government.
Page 9. Page 11, 9.
That is 2, 3, and 4. Raj Hussain. Raj Hussain, yes.
My lord will have page 7. Raj Hussain, page 9.
Page 9.
Now, my lord would see senior assistant headquarter level, 2 posts. My lord has got it. My lord will see how this posts are right. The resultant vacancies of 2 posts of plans have been called by promotion of plans. and to the post of superintendent due to selection of so and so for promotion to the post of inspector. So as on 2013, in that cadre, there were only 2 posts. Am I clear about that? Am I correct? Only 2 posts. Now, my lord, we have the.
Now, from where do you say that there are only 2 posts?
Because, my lord, it's nobody's case that beyond these 2 posts, there were other posts in the cadre. All other posts were filled up. It's nobody's case.
Yes.
My lord, we have the constitution 16. 16 OP.
Yes.
Nothing in this article shall prevent the state from considering any unfilled vacancies of a year, which are reserved for being filled up in that year, in accordance with any provision for reservation made under clause 4 of clause 4A, as a separate class of vacancies to be filled up in any succeeding year or years. And such class of vacancies shall not be considered together with the vacancies of the year in which they are being filled up, for determining the seating of 50% reservation on the total of number of vacancies of that year. So, my lord, the bar from interest on its case filled in, you cannot exceed 50%. Now, you can exceed 50%. Say, my lord, this is of 2013. From earlier, say 2008, 9, 10, the reserve posts were not filled up, and the post plus the roster point may be carried forward. Then in 2013, if those posts which say, my lord, 3 posts were carried forward, then there will be 2 from here. It will be 5. The 16.4b says those 3 carried forward posts will not be accounted for counting that 50%. Otherwise, my lord, 50% will apply, and 1 post at least cannot be filled up by reservation, even if my lord required it to be filled up by. So I am the senior most here.
No, from where do you make all these submissions in
Because
case of
my lord,
my
it's
note?
not their case that there were more vacancies available than, my lord, the vacancies which were filled up.
That's not the case of the department also. They are not referring to anything here.
The petitioners are doing it. It's there, I have put it in my affidavit also. It's,
The minutes does not reflect
minute says 2 vacancies have arisen now.
2 vacancies. Yes.
Not sure.
Now these 2 vacancies, whether is it open or it is reserved?
It cannot be. If it is 2 vacancies, 50-50. One will go for reservation, one will be for general law. If that is so, the post that is going, I am the senior most amongst all. I got promoted. Now my seniority in UDA cannot be questioned. The other person, he is not there. He is gone back. So they have been subsequently promoted. They are just below me. So the seniority is as it should be. Now what had happened, my lord? They have obtained an interim order from my lord that my promotion as UDA should not be controlled. My lord would see their order of promotion as UDA. In the additional affidavit, my lord, they are talking about the court. My affidavit also is that. My lord will have the revision. My lord, page 3 of the additional affidavit filed by the petitioner. Subject to reversion.
Page 3,
Page 3, my lord, additional affidavit has been filed.
paragraph. No, this is additional affidavit by
By the petitioner, Amit Kumar Das.
Amit Kumar Das. Yes, it was filed on 13 June.
Finally, 18/5/28.
18/5.
Why not we get it in my academic?
Yes, 18.5.
85.
Yes.
Why not we have page 3 then?
Page 3.
Lordship.
There is only page 2. There are 3 paragraphs.
The annexure is not given.
There is no annexure.
Annexure. Maybe it's not. Why not we have the academic file by
Oh, yes, it is here. Yes.
Oh.
Yes. 25 May 2015.
50. Subject to reversion without notice and assigning any reason thereof. The following junior assistants under the Directorate of Inland Water Transport are hereby temporarily promoted to the post of senior assistant in the scale of pay of so and so plus interest against the vacant post with immediate effect on the law. The incumbents are instructed to join on the books of such. So, whereas petition number 1 is serial number 2 and petitioner number
3.
3 is serial number 1.
What happened to 2?
2. Module 7. Module 7 and subsequently years. 31st is of the year. So, my lord, a promotion given to me, my lord, cannot be sufficient, be questioned because there are only 2 vacancies. My lord, I can have those facts, my lord, verified. The department is duty bound to produce that to your lordship. Because
So all these submission you made without verifying the facts.
so I have verified the facts, then made it further, because I have made an indication in my.
Then why do you need further verification?
For your lordship satisfaction.
Why? I had already asked for verification because the minutes does not reflect anything here.
Minute need not, minute says.
Minute need not provided the agenda
Fine,
for the
but
meeting
if it is
reflects.
too close, then my lord, there has to be a reservation only to the extent of 50%. Even if I concede to that.
Now, by that argument, the promotions made to these 2 persons.
Lordship. Promotion made to me,
No, not to you.
the other 2 persons.
Other 2 persons.
That is subsequent.
No, that is subsequently, but they are both reserve category.
Yes. How they have made it follow, they'll have to come up and show before your lordship.
By your arguments,
Yes, your lordship.
which you have not raised or pleaded.
No, I have only said, but this is a question of no matter because Mara will permit me to take.
But you have not pleaded.
He did to the extent that. I have only said in paragraph 6 and 7, the manner in which I was promoted.
Yes, you tell us. Without these instructions, how do we proceed with the hearing, Mr. Goswami? What is the status? On what basis these, whether these issues were considered, not considered,
Your lordship, the sitting minutes,
did not there.
it's not fair. They have not considered the question of reservation, our rights under 5A.
No, what I'm saying is, from my little experience of being on
I follow.
this side, that there is normally a
As it
agenda where all details are mentioned.
Technically required of.
No, this agenda will be a part of that file. That agenda reflects how many SERs are available. Supposing instead of 5, somebody's 4 is
Yes.
reflected, some DP is pending, all these details are there.
Yeah.
And then the minutes are on the basis of,
Including the reservation.
exactly. So it will be a part,
Required under the rule.
it is be a part of that agenda.
Yes,
Agenda.
yes,
So if the agenda reflects that no reservation,
yes.
then of course, we'll have to now find out that why the no reservation is there. But if the agenda does not even reflect on the reservation,
Yeah.
then of course, their appointments will have to be, the seniority will have to be restructured.
Obviously. Right on the conferred by the constitution as well as by the amendment of the 78.
Yes. So,
Why not we have the minutes of 13 as well as of
And
15
whatever I did
petition of
under the
153.
73 rules,
They are required from 8A
of
of the 98 Assam Directorate Establishment Ministerial Service Rules 1973.
you want the rule? Rule number?
Rule 8AA. General procedure of promotion.
Yes,
If you want to kindly see.
details about reservation.
Sub-rule 2. The appointing authority shall then furnish to the selection committee the following documents and information with regard to as many incumbents in order of seniority as are eligible.
This is the agenda.
This is the agenda.
This is what the appointing authority gives.
We are specified
Yes,
information about the number of vacancies, list of incumbents in the order of seniority eligible for promotion to the rank of superintendent and registrar, ACRs of last 5 years of eligible incumbents of my life. And kindly see the details about the result.
correct. That is what I'm saying.
So they have to give that.
They have to, but it is not there on the pleadings anyway.
They have to, because they have not mentioned all this.
Now, what is your, you also claim under the reservation rules?
Reservation Act and the rules and
Rules.
constitution. So,
Yes.
rule, in this period, reservation is mentioned. as-
What is the cadre strength of this post?
Senior assistant is 30.
So there is no dispute.
There is none in the list.
In that list you have furnished.
They can verify. They can verify the department can pay your work. That is the position we find from the report.
That's true, it was 30, but in 2013, there were only 2 posts. Then that bar under 50% will come in. The second post I cannot argue. First post, as far as I am concerned,
Because
it's beyond.
the requirement under the law is the law. If you have a cadre and you have these 3 candidates from the 3 reserved categories, which are given the earmark quotas in the cadre, and you don't find even a single person of those 3 categories in the list, and there are vacancies. It is obvious that you have to fill up the strength of the 22%. And I can't believe that you will stop only at 50%. No, that's not the law.
Sorry, but that's not my submission.
No.
My submission is there are 2 vacancies
You can't.
or X number of vacancies. Only 50% of that vacancies can be reserved for general category.
I don't subscribe to that.
50%. I'll place that.
Yes,
I'll place that.
You'll have to fix up the cadre strength
Why not?
and then have a,
That is exactly 16(4)B.
No.
After Sabharwal, it's 16(4)B.
no, 16(4)B is where it was left out.
Well, that's it. If it was not left out,
Ah,
then my lord, you still cannot have more than 50% in a year. Why it was left out? Why it was not left out? That those arguments have to be built up, my lord. Those arguments have to be built up that they were reserve category coming.
how can the petitioner build up? They are similarly placed.
That my lord, register for your lordship.
Who will produce it?
They have produced it.
Ah.
They can make a submission from that, my
No,
lord.
no, they have produced it to the court. That this is come to their,
My lord, to get to the root of it, my lord, we'll have those minutes. 13 as well as 15. How they have done it.
You know, if they go by the law, they are required to maintain a register under the law.
They have to.
And you produce that register. You
Roster
have not
register.
done it, you have not mentioned about it in your
That's true, but
academic, you don't produce the records, and you want the court to say that only 50% will be filled up. What is it?
But in a year beyond 50%,
In that event, you will not kindly see, test the argument. You have a cadre of 13 posts.
Hmm.
All are unreserved occupation. There is a vacancy. There are 2 vacancies there.
Now, would you not, if there are available reserved category candidates in the process of filling this two posts, that is, would section 5A not apply to fill up the vacancy quota for this particular category? One is a scheduled caste, one is a scheduled tribe, one is a plain.
What is
I'm
your,
concerned with the first two.
Why not we have that 16(4)(b) last two
No,
lines?
no, 16(4)(b).
no, 16(4), yeah, can we read 16(4)(b) again?
Not yet.
There was nothing to do with that.
Nothing in this article shall prevent the state from considering any unfilled vacancies of a year, which are reserved for being filled up in that year in accordance with any provision for reservation made under clause 4 of 4AA as a separate class of vacancies to be filled up in any succeeding year or years. Now, if I may just pause here for a minute, as I am say in 2011, well, there were 3 posts of reserve community candidates vacant or roster points were available. There was no candidate. Now, if these 3 posts are filled up by reserve, filled up by general community, then only the roster point gets carried forward. But if these 3 posts are not filled up, posts are carried forward, then they come to 2012. In 2012, my lord will see that there is 1 vacancy or 2 vacancies which are arising. Or 1 vacancy has come. Now 3 plus 1, how much, my lord? 4. 3 plus 1, it will be 4. So applying that 50%, only 2 posts can be given for reserve community. But because of 16(4)(b), those 3 vacant posts which have been carried forward will not be added to the vacancies of the next year for determining the 50%.
Correct.
So if that is so, my lord, even a my lord will have the last line. The year in which they have been filled up for determining the
No, we are with you.
50% reservation on the total number of vacancies
We are
of that year.
We are with you.
That
Yes.
much will be.
Yes.
I'm only on that.
So what is it that you are submitting with reference to?
Because
4B?
if there are only 2 vacancies arising in 2013,
Hmm.
then 1 only can be given for reserve. I will give it.
Subject to it's being in conformity with the
That's
roster
what I'm saying,
register.
I'm just
The
making a
register must
submission.
be available, determining.
But what I'm trying to caveat is
Hmm.
my promotion in 2013,
You are saying that either way,
I'll be safe.
you will be safe. Your counterpart who's no more here may not have been safe because you are senior.
So I go.
That
Then
is,
even if they are promoted along with me in that year also, my lord, 5 provisions of rule 5 of the scheduled caste, scheduled tribe, rule 12 protects me. Because it's seniority company.
no,
promotion.
for that, you must be satisfied that this post which arises for that particular year is to be filled up by only unreserved.
No, even if there are only 2 posts, only 1 can be filled up by unreserved, 1 has to be filled up by reserve because of the 50%. Or they'll have to show that the posts in the earlier years, posts were carried forward, not points. There is a difference, my lord. Points being carried forward and posts being carried. 50% will apply to points, not posts. I'll please, my lord will have both the manuals. That may help both of us. 15 manuals, or the petitioner promotion as well as mine.
They would love to produce the records. They're,
Whatever it is.
but we are not producing the records unless you produce them and point out the relevant section.
But she'll have to peruse both them, then only my lord will get an idea.
And also will not be maintain a register showing.
Roster.
Roster points.
Yeah.
Third letter counsels for the artist, this declaration is implied by the petition. Challenging the promotion of the private respondents to the post of, which post is it?
Senior.
Senior assistant. stop this court while issuing notice on 9/1/2015. Passed an interim order that the temporary promotions of respondents 5 and 6 in the post of senior assistant shall not be confirmed. So this interim order is still in force. Stop. Pleadings in the petition are complete. Pleadings in the matter are complete. Although initially the prayers made by the petitioner were with regard to interference with the promotional order granted to respondent 5 and 6. It is stated by the learned counsels of the bar that in the subsequently petitioners also were promoted. So therefore, the question now required to be determined is the seniority in the post of upper division. Yes, I still. No, if legality to the extent of determining the seniority.
There is already an order of this on.
Or you're still challenging.
Appointed on that
So-
post, is there question of before your order?
I'm sorry, my lord, there is an order of this on the court.
Hmm.
My lord Justice Suman Shah 28/3/23. Wherein my lord, the issue has been now limited only to senior. If that, my lord, the last rules again, my lord, and the court has also taken note of, so I.
When your lordship will go through the entire pleadings and entire.
Your lordship
will find your person taken for that.
In order to determine the seniority issue from us, the court considered it appropriate to direct the respondents state to produce the relevant records pertaining to the promotion of the petitioner as well as the respondents 5 and 6 and the roster point register maintained by the department.
Right,
Stop.
right, right.
Whichever department. Let these be produced before the court of perusal, if required, for the next date fixed. When can you produce it?
The seniors. My lord will have it. 24th, my lord.
24th.
29th.
29th. Yes, accordingly, 29 August.
And will not be, for that.
So it's 29 August. Yeah. For 29th, I'm informed there are partner matters listed.
Lordship. Only will have it.
Then we can have it on 31st.
Lordship.
31st.
And will not be, the in charge. One, one respondent has been made in charge to build. So he should not be confronted. Because we are already prejudiced by.
Who is made?
I am the in charge superintendent.
That interim order is there unless you
I
are,
should not be confirmed.
unless you are confirmed in the,
Here,
that is there. It will continue. Interim order pass.
That is with regard to seniority. Now.
No, unless he's confirmed.
Correct, but I give it to your lordship, but the inside superintendent, he should not be confirmed. That should be fair.
In view of the interim order passed on so and so directing that the respondent so and so will not be confirmed in the post of duty. As it is informed in the bar, as it is submitted in the bar, the respondent number 5. Has in the meantime been further promoted to the post of superintendent.
Allowed to hold the charge.
Allowed to hold the charge. Then where is the question of confirmation? He is allowed to hold the charge.
Hold in charge, and in charge.
Then he can't be confirmed. No, your submission is that he's been allowed to hold charge in superintendent.
As superintendent, let him hold, I have no problem, but let him not be confirmed there
Where?
as superintendent.
He can't be, he has to be promoted.
That interim order will my lord will explain.
The interim order
Say that.
shall continue. And Any further promotions that may be given to the respondent number 5?
No, no promotion has been given. Your Lordship will not.
Shall we with the leave of the court? Watch if you want. It is further submitted, the respondent number 6. In the meantime, it expired.
That's already taken over. Stop off.
Struck off.
Well, now, five, your Lordship will not say promoted because they have not yet promoted. Any, only in charge, he has been made.
How can you be confirmed in charge?
That is right, I understand, but the promotion was they might.
We did not want to, you insisted that something is to be done. So we'll extend the interim order passed earlier. We'll continue.
That's right.
You stop it at that.
I was saying that we have filed an application with regard to the second in charge thing. So your Lordship may say that you not be confirmed in that. That's all.
In charge, how can you be confirmed?
I want to say-
I will also be taken up.
It was swallowed. Some people like no big there. In fact, perhaps it will be correct if I reply to their long stand.
We are informed there was some
Yes.
medical something.
In my life cannot walk properly. There's something maybe there is no particular. The doctor checked said it's okay.
We didn't go with the direct, we didn't ask your presence here. We had already passed some orders, I think, no?
Miscommunication.
We were inquiring about,
He was
no, we were inquiring whether Mr. Dubey has landed or not. That is what we were.
Could it be after 2 weeks?
After 2 weeks. The request for the council.
Continue.
There are no-
I'll follow others. Perhaps it will-
Harassment case.
Yes, yes.
So we have filed our response.
Parties may change their feelings.
I have to complete.
He wants to file,
No, I
Yes,
have filed.
you have filed.
As per the direction. of-
Petitioner may file reply affidavit if so request. The affidavit in opposition filed by the respondent, airport authority.
Time being item number 33.
Yes,
Although I tried something.
so what can be done now? You have already been promoted now. You've all been promoted.
But then my seniority and the delegates, we have to put the date,
That will be considered by the department, let them consider.
To observe that because in terms of that. Document finding at page 18. Clearly provides something. The last one was this. Rule 3(2)(b). Any gather or post laid down by the government will be included in a gather on the science. Government is the competent authority document. And apparently also that was not done by the government. Because the director general will be the page 36 or.
You are now all working as superintendent. Superintendent. And he is senior.
He was, yes, assigned seniority by.
Yes, Mr. Nair. The respondent is not available.
No.
So we dispose it off with a direction to the government to address your grievances. And considering the fact,
Interfere with this because interfering with the interim order may is downgradation. But my lord will make a clarification of that observation. That is not problem. Not saying my lord will disturb this whatever benefit he has. but-
no, we will say that in the absence of the councils, we could not be benefited by the arguments to counter your submissions, basically. And government has informed, who is there for the government? Government has informed that both of you are promoted now. So your original prayer for setting aside and quashing.
9/9/20. But my lord, this will never bear because if this stands, then my lord, the consequential action is the promotion. Otherwise, he will not be.
Then we do one thing, we permit you to take steps by dusting. Again, on the respondent. You take steps by dusting.
Trustee on the response.
Because he has to be informed that his counsel is not here. If he wants, he can
My lord
appear.
will give me, because I have also not been able to contact the petition.
That's the whole problem.
My lord will give me a chance to take it by registered post. I'll give the tracking report. Tracking.
So registered post will not serve because
Oh,
again, the question of
My lord, I will give a copy to the respondent counsel, my lord.
you serve it through the respondent's office.
Lordship. No, but I'll give it to the, because I'll give it to the council if they can give it to the thing and then get it. Madam. I'll give a receipt also.
You're both working in the department.
But my client is also, my lord, I'm not.
Then why do we waste our time disposing of the
Because
matters?
I have instructions not to press the matter, so it may, tomorrow, my lord, it may have a conflict. The only prayer is, my lord, will permit me to take this step to the respondent number 2, I'll serve a copy of my plan, madam. Director General of Civil.
You can always argue, no.
I'll do one thing, but I'll have
Something of this matter.
I'll do one thing, my lord. My lord will give me the liberty to take it to the Director General of Civil Insurance. Through him I'll take. No. My lord, slowly permit me.
Heard learned counsel, heard Mr. Nair, learned senior counsel assisted by Mr. Ambesh Sharma. Mr. R. Ford, learned government advocate appearing for the respondent department. Although respondent number 3 was represented by counsel.
Affidavit also.
And affidavit has also been filed. However, for the past several days when the matter was called up, the counsel representing the private respondent is not available before the court. The last recorded appearance of the private respondent is on 4/9. Counsel for the private respondent is on 4/9/2018. Sorry, 26/4/2022. 26/4/2022. Stop. Meanwhile, the learned government advocate has informed the court that as on date, both the petitioner and the respondent number 3 have been promoted in due course and are working as superintendent. Superintendent. No,
Assistant.
have been promoted to the next higher post in the
Next
department. So, under such circumstances, the only question which is required to be determined is the inter se seniority of the respondents. So, however, since the order, where is that impugned order?
My lord, the interim order, my lord, is fine. Page 36.
Since the impugned order dated 9 September 2010, passed by the Director General of Civil Defense and Commandant General of the Home Guards, Assam, whereby the private respondent was encadered, has been challenged, and any order passed by this court interfering with the state order will have the effect of will have adverse effect on the service of the respondent number 3. Stop. In that view of the matter, the court is of the considered opinion that since the learned counsels for the respondents have not entered appearance as discussed above, the petitioner is permitted to take steps again on the respondent number 3 through the office of the respondent number 2, namely the Director General of Civil Defense and Commandant General. Stop. The petitioner will furnish copies of all the pleadings filed before this court and serve it on the respondent number 3 through the office of the respondent number 2. Stop. The affidavit of compliance will also be filed by the petitioner as well as the respondent number 2, stating that the copies of the writ petition as directed by this court in terms of this order have been furnished to the respondent number 3. So let this exercise be carried out within 2 weeks from today. Matter be listed after 3 weeks, enabling the service of notice to be enabling service of notice as directed. Stop. We are not putting in the order. In the meantime, the council appears. You are entitled to make a mention.
Not really.
But then we pass appropriate orders because it's a very old time. This after 3 weeks at a meeting.
Why not we fix it so that why not if the opponent be concerned. Okay.
18th of September.
No, 18 no, let it be on 12th. 12th September.
Typing items 21 and 22.
What is the interim order passed?
My lord, in the first case, the promotion of the private respondent, my lord, was stayed, and he is continuing to draw the salary of LD. My case was, my lord, that post is not in his hierarchy,
We should modify this and make it subject to outcome.
because, my lord, I am entitled to that promotion.
So subject to outcome.
No, because he is not entitled, I have challenged to that. I have challenged that. And there was a stay order.
But then there is no vacating petition.
There is a vacating petition.
There is.
There is a vacating petition, and it was directed to be heard.
Where is that vacating petition?
Vacating petition, my lord.
I am 1270.
Right. You have filed your counter affidavits.
Yes,
Your counter affidavits are filed.
yes, everything ready.
Then Mr. Bora wanted to file something.
No, he wanted to file the case in the second matter, connected matter.
Item 21. 7-6-2.
21, there is no interim order.
No, they are doing anything. Only they are challenge now. They are about their reduction dispatch.
That gradation is one of, is there is a direction not to act upon that gradation. My senior client is not a man.
He is not a party.
In that case, madam, they had brought in, this first case, they had brought in materials which we have to file the second case.
In 2177, you have filed your affidavit.
Yes. In 7626, the pleading otherwise complete, but the requirements have been removed.
So tell us what to do, we'll admit it. Thanks for hearing that.
One of the person who is not in the line has been brought and promoted. And the analogy now taken is that there was a direct recruitment, if my lord, that is, I'll be arguing about that.
What are your grounds for modification?
Before stay order, my lord. I have joined in the post, my lord.
You may have joined, but he's questioned your very eligibility to be considered for.
No, that is the main case, that will be considered.
Secondly, if you're not eligible to be promoted prima facie, because the coordinate bench while issuing notice has recorded prima facie finding that you are not. You don't belong. So if it is there, then you have to, if you have pleaded any ground to say that this prima facie finding on the basis of certain documents or proposition of law is not correct,
No, they change the change idea, joining in the proposal.
then we'll have to, then see. We can hear the matter, but standing counsel wants to file some reply.
No, in this case, no, they have only kind.
The other, both the matters are connected matters.
In the second case, they have not filed appeal.
No, both the matters connected, Mr. Nair. Both the matters are connected.
Yeah, the decision is of my statistical official matter. Not to decide by hand.
So why we have a connection? My senior client is an LD. He has been brought to the post of research assistant. Now, while I assailed that, they filed a affidavit, the department, saying that we have now amalgamated like SCRT, everything amalgamated. But the amalgamation is only to the respect of statistical assistants. LDAs have not been amalgamated. Now, statistical assistant, according to them in the affidavit, the next promotional post is research assistant. We put it to a challenge that a director cannot amalgamate the posts, the services, 3 different services. It has to be done by the government, and there is no order of the government. So if, my lord, that analogy is also followed, then, my lord, the research assistant, the post of statistical assistant, the promotional avenue is research assistant, LDA is UDA.
How many petitioners?
One.
How many posts of research assistant?
One.
Only one.
One. The other 2 posts, my lord, are my lord under the central government, some temporary posts have been created. This post was created specifically for the purpose that statistical assistance does not have a, my lord, an avenue of promotion.
Then how is this connected with the other addition list?
Because now they say that all these research assistants of these 3 wings, sorry, statistical assistants of these 3 wings have been amalgamated, right? And SCRT have been amalgamated, and there will be one senior. I was at serial number 1 in SCRT. Now I am serial number 16 because of this amalgamation.
With regard to this matter, you are challenging his promotion to.
Because they have taken that plea here, my lord. They have brought that that thing because I am not even eligible for that promotion because I am at serial number 16.
Why after amalgamation?
After amalgamation, but they have failed to bring on record an order of the government.
So essentially, we have to hear
Both together.
not both together. We have to decide on this matter.
Say first one, 7626.
Ah,
Then my lord will come to this.
then, so in that view of the matter, why deprive him?
This I'll show my lord how he is not entitled. I'll show from the pleadings itself. I'll show from the pleadings itself. This honorable court has already taken up.
When are you filing your affidavit? Second week. Second week of September. You have to justify your amalgamation. That's all.
Because the post which my senior is now, senior client is now filling is an upgraded post of statistical assistant. Page 28.
Let it be on 7, but 7 no.
28 of which writ petition?
The my lord 2176.
170.
My lord will see how it has to.
Yes.
With reference to your letters of the I am to inform you that the government has agreed to upgrade one piece of statistical system. So and so to that of research assistant in the scale of pay so and so. This has confluence of so and so. Now my lord would see the promotion scale. The first one, my lord, at page 32. This is of 93. As per government letter dated so and so is upgraded to the post of research assistant in the scale. So Goswami Gopal Chandra Goswami was first upgraded. Then my lord, after Gopal Chandra Goswami retired, my lord would have page 36. Deepti Sharma came. So this is the hierarchy, long-standing practice.
There are no rules as such.
There are no rules. This is how my lord will have to understand this. Then my lord 37, after Deepti Sharma retired, promoted and retired, then my lord, Rupa Kumar Bhattacharjee was done. Then after Rupa Kumar Bhattacharjee, the next incumbent is me. Now when my case was to be done, all of a sudden, a minute first, my lord, is there. Page 42. Page 42 is the impure order, my lord.
And what is the next higher post?
Then, my lord, it would be research assistant. My lord, it would be assistant research officer. Out. Then research officer, then senior research officer.
So what are the qualifications for research?
The qualifications are graduation and my lord, maths and statistics there. But they have now taken a plea referring to my lord. My lord, just a plea. The affidavit of the respondent number 2 and 3, my lord. They have now trying to project a picture that in 2001, this post of, my lord, some post of research assistant was advertised by the APSC. At page 16, my lord, in that affidavit of the respondent number 2 and 3. Page 16, my lord, would be. How they are trying to draw an analogy now, my lord. One post of, my lord, serial number 4 at page 16, my lord has got it. One post of research assistant, the directorate of Seniority, Assam Kailipara, age 18 to 36, this they have forgotten. Scale of pay so and so. Qualification, degree in arts, science, commerce with maths, statistics, economics as one of the subjects in degree course from a recognized university. Candidates must possess minimum 10 years of experience as LDA, UDA, statistical assistant in any department institution under the government. Preference will be given to candidates having capability to prepare departmental plans, so and so, so and so.
You are challenging this.
No, this is their analogy. My lord would have the minutes at page 18.
No, but experience says you have to work as you can work as an MBA.
No, that is for direct recruitment. With then the educational qualification will come degree in arts, science, commerce with maths, statistics, economics. Then my lord will have the age.
What is good for direct recruitment for experience? Why is it not good for promoting?
But where is that thing that same analogy will apply for the direct recruit?
Where is it that it is not will not
Because
apply?
the standing practice is, my lord,
Standing practice is
statistical
there.
assistant to research assistant. You will have that rules, my lord, that minutes, how they have done it.
Yes,
My lord, at page 20.
20.
Okay, now. This very okay, sir. I think I'll just try to read. See, Hemchandra Baba so and so obtained the requisite qualification and qualifying service in the post of so and so required for assistant under the establishment, and there is instance that my lord will see. LDA, UDA of so and so and promoted to the post of RA having required qualification experience. where nobody, not even a whisper. However, hence the committee recommended so and so may be promoted to research assistant. And that advertisement is of 2001. Whether any person was appointed, what happened, no disclosure. And my lord have seen in the petition that this is a post upgraded from statistical assistant. And we have been regularly being promoted. He has an avenue.
What is his avenue?
His avenue is UDA.
What is the department's stand?
Departments, and that my lord, that affidavit my lord is holding. Your lordship would have para. Then they say my lord everything amalgamation, para 10. Para 10. It's here, the director's whims and caprices that are going to. My lord would have the second line, 1, 2, 3, 4, 5, 6, 7, 8th line of para 10. It may be worth mentioning that there is no service rule of SCRT or the post of like so and so, so and so, so and so. So it cannot be said that statistical assistant is the only feeder cadre. Feeder post for research assistant. The post of research assistant can be filled up from statistical assistant, UDA having 10 years experience in planning matters. Qualification gone. As per earlier advertisement published so and so, is degree in science, commerce with math, statistics, economics as one of the subject in degree course from recognized university and 10 years experience as so and so. So and so with so and so. That out of the 2 vacant posts of research created under so and so, one has been filled up by so and so, the senior most so and the post of research assistant under the establishment of expenditure so and so, under the director, has been filled up by promotion so and so. As per recommendation of the so and so, it is particularly mentioned here that so and so could not be considered by DPC as a position of seniority in the credential list of so and so is 16. My lord, you have not even considered that list. You have brought in a LDA and then promoted it. You didn't even go to the statistical assistant. Then, my lord, would have why I filed the next case, my lord, page 30. Para 30.
Yes.
Here, my lord, they say the answering respondent begs to state that the petitioner is not the senior most. So and so under so name is in serial number 16 of the final edition list. As such, she could not be considered not being within the zone of consideration for promotion to the post of research assistant. Now, this would mean that the LDA and research assistant are the same. Otherwise, my lord, how can there be 2 zones of consideration? The respondent number 4, so and so was promoted to the post on fulfillment of qualification and experience laid down in the advertisement of so and so. So direct recruitment, now that is being adopted for promotion as per their convenience.
Where is the convenience? It's a question of there are no set rules.
Need not be, but my lord, there is a long-standing practice, that is the law in itself, my lord. From 93 onwards, you have been filling up the post in a particular manner. Now you have to take a different course of action. You have to take a decision. The government has to take a decision. 93, this post, because of lack of promotional revenue of statistical assistance, one post was upgraded and made research assistant.
And what was your challenge in the first petition?
I have challenged the promotion of so and so, the private response.
You were not aware of the revision list.
No, it was not there. After filing of the written statement, we came to know about the affidavit by the respondent number 3, we came to know about. Immediately I put it to challenge and that was also taken. And my lord, it's an undated one. Right? And SCRT amalgamated. And my lord will see, if institutions have been amalgamated, right, it's a different institution altogether. It's under the control of the director. SCRT is a different institution altogether. If there is an amalgamation, amalgamation has to be in respect of all posts. LDAs have not been amalgamated.
On what basis are you saying that all posts will have to be amalgamated?
Otherwise, my lord, what is the beauty in my lord, one post being taken up an amalgamation?
It is the decision of the authority,
Which authority, my lord?
the director,
How can she be the authority, my lord?
because there are
It's the
no
government.
rules. There are no rules.
There is a SCRT rule. my lord.
When your predecessors have been promoted, nobody demanded the rules should be in place. It was
Need not
merely,
be, but my lord, there is a
carried
concept-
on.
there is a concept called, my lord,
That is
long-standing practice.
that is the danger of long-standing practice.
My lord will have one thing. my lord.
That long-standing practice cannot be,
My lord, let them bring and show.
long-standing practice cannot be that it can never be changed.
I even concede to that. Let them come and show before your lordship that there was a decision of the authority.
Yes,
which was
Mr.
more
Bora,
likely.
your affidavit, you can forget it, get the records. We'll
Yes.
hear it. You get your records and show us how
On
you've done
both,
it.
my lord, on both.
Get the records as to how these were amalgamated.
And also, my lord, how he was promoted. Because
It will
the,
be available there.
no, my lord, the DPC cannot be, entire record leading to the DPC.
Yet if you're not filing because this has reached a stalemate.
Okay.
Because of the, I don't know whether I should use the word, I'll appreciate, in an appreciative manner, I'm saying it. You have filed the affidavit in the second petition. In the challenge. All right, it was filed earlier, but the core issue remains in the other petition where you have not filed it. So unless you file it,
And if they come up with a stand that the DPC is the topmost authority, they can do anything. My lord will report that. Let them come up with that stand. Because there is nothing on record to show that an authority had taken a decision in this matter.
here, Mr. Das, I think we need to hear the matter. Taking up only this thing will not help in the absence of the affidavit being filed.
Understand? It was a promotion post he got issued. My lord will fix a short date, let them forget the records, forget the affidavit, my lord, let them have the record.
When can you fix it? When can you get it? See, this is the problem here. This short date or long date, we are going for a full scale hearing.
Lordship, my lord will have it on a hearing.
So ordinarily for admission, this is not a matter to be heard in admission. Then
Because my lord, the IA was also not entertained because of that only, the matter should be.
you give us your dates.
My lord will have it on, but if not.
30, we'll have it on 31st.
My lord has been.
31st,
31st, done.
31st August. Heart Learned Council for the parties, the petition pertains to the challenge to the promotion made. Writ petition, what is the first one? 76
No, my lord.
2177.
217720.
WPC 2177 pertains to the challenge made to the promotional given a private respondent. From the post of LDA to the post of research assistant. Under what?
My SCRT.
SCRT. Stop. This court had granted an interim order by issuing notice. Suspending the motion made to the private respondent, and the interim order still subsists. Stop. The private respondent has filed an IA, the IA number so and so, seeking vacation, modification, alteration of the interim order. Stop. The pleadings in WPC so and so are complete. In WPC 7626, the Standing Council SCRT, Mr. Bora submits that he requires a short date to file affidavit. The same writ petition has been filed, putting to challenge the gradation list, the combined gradation list
Of statistical.
of statistical assistant,
SCRT and DIET.
SCRT and DIET. On the basis of which the promotion to the private respondent in WPC. 2177 was made. And in that view, the matter, both the matters have been tagged together.
One of the promotion was not made on the basis of that.
Hmm.
They say I am not entitled because I am a serial number system.
That's right. It is that serial number 16 of which list?
Of the gradation.
That's right. And
And he is not there.
he's not there.
He is not there. That's the beauty matter.
Not a record part.
They say I am not in record.
Not will enter, put in the record.
Was not considered.
I mean, that is the matter,
Yeah,
both the
that-
matters have been tagged
Taken
together.
together and an attempt was made to dispose of the matter. However, in the absence of the affidavit being filed by the standing council, matter could not be disposed of today. The standing council is directed to produce the connected records relating to the promotion made to the private respondent in WPC 277, as well as to the order of amalgamation of
And the preparation. of the
research assistant of diet and SCRT. And
SCR. And the preparation of the gradation, that will do.
and the consequent preparation of the gradation list be produced below the court on the next date fixed. On which date the attempt will be made to dispose of the matters. Matter will be fixed on 31/8. It will be on 31. IA will also be taken up on the same day.
Daily list for hearing item 26.
CGC, who's CGC? Where is the CGC? Yes.
Challenge is the infraction of Rule 27.
Yes,
My basic case is the infraction of Rule 27.
this is what CRPF.
CRT.
CRPF rules. Actor rules. Yes,
But it was an incident around 4/98. He was posted in Gurgaon. And the allegation is that he was intoxicated, in that state, he had misbehaved. And entered the officer, residence room, senior officer, and destroyed his personal belongings. Picked up a quarrel with the civil police. Damaged the gypsy, and also disobeyed orders, did not attend the room call. There were 4 charges that were leveled against him. In fact, a criminal proceeding was also initiated that not resulted in his acquittal, because no evidence to be used by them. Now, here this case, he was dismissed from service. The inquiry was done. My cases, I was not able to participate in the inquiry. I had to leave the inquiry in between because of certain threats. And I'll show that he was not given a opportunity to file his pretty statement also. And he was finally dismissed on 19/11/99. The order was not served again. Thereafter, after his dismissal, acquittal in the criminal case, of course, he filed a appeal. That was also dismissed. The revision was also dismissed. Allegations, charges will not be kind of pay.
yes.
Of the report.
38,
Page 18.
88.
18.
Yes.
At the same following 4 personnel while functioning. In fact, the allegation against 4 personnel. But subsequent it is
It is reflected in page 38 also. No,
well, that's 38. Yes, sir, it's there in 38.
so better to read from 38 is more legible.
Well, what's the year? Either 18 or 38.
38, more legible. 4 personnel.
4%.
Your number,
I am number 2, man.
2. Rajpal.
Last further. But what happened with the inquiry with the procedure is thinking experience. They were separated. I don't know whether it was separate, but it was separated into single.
Mr. Chakraborty, what happened to the other 3 persons? So what, have they come before this court?
I don't know.
You don't know. All right. You're not aware of any orders passed, okay. Yes,
The same 4 personnel and functioning as so and so. On 4/6/98, committed an act of misconduct and misbehavior in the capacity as members of armed force under section 11(1), CRPF Act 49. In that, they consume liquor and then they misbehave with OC, and use abusive language against so and so and other personnel in the state of intoxication. There's the 4 persons. These are the fiction is the 2. Article 2 to the same following 4 personnel were functioning as so and so, committed an act of serious misconduct and misbehavior in the capacity as a member of force under section 11(1) of CRPF Act 49. In that, they entered into the residence of so and so and torn his personal belongings, broken window and other property and then and then the same 4 following personnel were functioning as so and so, committed act of serious misconduct and misbehavior in their capacity as members of the armed forces under so. In that, they picked up a quarrel with the civil police personnel and tried to damage gypsy of civil police and also behave to the time of the civil police. Article 4, the same following 4 personnel were functioning as so, committed disobedience of lawful orders and executing in the capacity as members of the force under so.
you're not put into custody during the inquiry.
No, man.
Where were you?
Lord, I was there when I participated, my lord. Then I was threatened, my lord. I had to leave the inquiry in between, my lord.
Did you file any objections, FIR, anything like that?
I did not file it.
Then
I didn't file it. But I'll show from the records also whether there is some other important thing. My lord. My case is that I was not allowed to file a written statement, my lord. And my lord,
now on what basis you are saying that?
my lord, they're not able to do that. That I did not file a written statement. Lordship is procedural initiative.
No, you did not file, but your contention is you are prevented from filing.
Yes, sir. Yes.
On what basis are you saying that?
Well, they are saying that I resorted, I'll show you lot because I'll show just from the records, they have filed an affidavit. And before that, the base will rule very much, that will make things clear. Because there's certain procedures we follow. Rule 27C matter. This is where we did not follow the procedure. Right from 27C. 1. The substance of the accusation shall be reduced to the form of a written charge, which should be precise as possible. The charge shall be read out to the accused, and the copy of it be given to him at least 48 hours before the commencement of the inquiry.
This was done.
Yes, sir. And the commencement of the inquiry, the accused shall be asked to enter the plea of guilty or not guilty. So that question itself was not asked. Though they have tried to say that I did not, I kept mum. I did not either say guilty or not guilty. Their own records will show that question was not even asked to be asked. After which evidence needs to necessary to establish the charge validity. The evidence shall be material to the charge and may either be oral or documented. If oral, it should be direct. It should be recorded by an officer conducting the inquiry itself in presence of the accused. The accused shall be allowed to cross examine the witness. When documents are relied upon in support of the charge, they should be put in evidence as exhibits, and the accused shall, before he is called up to meet his defense, allowed to inspect such exhibits. The accused shall then be examined and his statement recorded by the officer conducting the inquiry. If the accused is pleaded guilty and does not challenge the use of the record, the proceeding shall be closed for the orders. If he pleads not guilty, he shall be required to qualify a written statement and a list of such witnesses as he may wish to cite in his defense within such period, which shall in any case not be less than a fortnight.
as the officer conducting the inquiry may deem it reasonable in the circumstances of the case. If he declines to file a written statement, he shall again be examined with the officer conducting the inquiry on the expiry period allowed. Well, I just pause here for a moment. And our lordship, I just take the lordship to their paper.
No, which of the conditions are violated?
Well, exactly. Lordship will finally see the 804. Well, this is the question that was, this is the question that was put to him. Well, the initials, I mean, not very sure because there's some.
Yes, which
But
one?
I think that perhaps it's 104, Miller. It starts with question number 1. Yes. Lordship will see here, Miller. What are the questions that have been put, Miller? Question number 1. Rajpal so and so, memorandum annexure which was sent to your home address by the commandant so and so. So registered person so and so, apart from this copy of the office order for appointment and inquiry was also sent to you on 3/8/99. So registered post, have you got the letters in order? Yes, sir. There are mentioned documents are received by me. Question number 2. All copies of orders of commandant so and so departmental inquiry against you, including memorandum of charges in 123. Order regarding appointment of inquiry officer have been read and make you understand in Hindi language. Did you understand well each and everything written in those orders? Yes, sir. But the orders which you have read and tried to make me understand, we have got that with me. Do you have an objection to me as an inquiry officer, or do you want to ask any other officer to be appointed to conduct a departmental inquiry against you? No, sir, I have no objection to inquiry. Which language you understand well, Hindi or English? I mean to say that it's a language you want to departmental inquiry to be conducted. Answer: I understand Hindi language, so I want to inquire if my inquiry to be conducted in Hindi language. So there is no question asked whether I do not plead guilty to the offenses of titles of office. So that whether I plead guilty, because there are cases that I can get one melody and did not utter whether I'm guilty or not. That is the same that they're trying to say that I cannot cooperate with the inquiry. But this question reveals this question was not asked at all.
No, but the very fact that the inquiry proceeding has gone,
Yes.
it is on the ground that you are guilty.
Well, I think that's what I'm telling you, because this proceeding has not been done in proper manner. I'm coming to that. Secondly, I was not asked whether I wanted any defense assistant or not. He being a law ranking officer, a constable, and being post case, I was a higher officer, he often asked this question. And so this is that it's though it's not there, but
These are the only questions asked.
there are other questions asked later on, but this is the first.
Where are the other questions?
Yes, but before that, Lordship will kindly take this the. Next, let's just see.
Let us first look into the questions put to you
Yes, sir.
and the answers given.
Yes. Annexure F, page 115.
Yes. This was asked. Page number 115, question number 1 is that whether you plead guilty or not.
My that why so and so was functioning as so and so committed an act. This is the question whether he guilty or not. Refuse to give any answer. I said refuse to give any answer. That question was not even asked.
No, but this is
He
the question asked, to which you refuse to give answer.
But my case is that I was not, my case is that I was not even that opportunity.
No, 115 is what?
Yes, 115,
This is a.
because before that, my lord. Before that, my lord, this was the next time, Lordship may kindly shall to the 103, my lord. Sorry, not 105, my lord.
10.
5. Because
Right.
that stage comes later, my lord. First, my lord, once the charges, my lord, because the charges are placed before him, my lord, he has to read to him, my lord, and he has been, my lord, faced after the video being placed against your lord. 105, what you will see, my lord, these are the questions which are asked to the, my lord, the witnesses, my lord, the prosecution witnesses, my lord. All in the form of leading questions, my lord.
He's kind of, uh, you see, this is not a criminal proceeding.
Even in the criminal procedure, leading questions cannot be asked to a witness.
That's what I'm saying. This is not a criminal proceeding, this is a departmental inquiry.
Yes, my lord.
So departmental inquiry are being conducted. The only question is, we'll have to see whether the procedure has been prescribed.
Right.
Has been followed to what extent prejudice has been caused to you.
Yes, so therefore the first thing that what we have done, my lord, is read over the charges, my lord. And my lord asked me to whether I plead guilty or not, my lord. That is what Rule 27 will say. Rule 27, my lord.
No, therefore I'm asking you,
So at the
what are the queries put to you and what are your answers?
Exactly. At the commencement of the inquiry,
Hmm.
at the commencement, the substance of the accusation shall be reduced to the form of writing.
No,
The charges should be read out.
Mr. Doctor,
Madam.
we are with you, that question was not put.
Yes, madam.
Now you tell us what other questions were put and what answers were given.
Madam, that first stage, madam, no question was asked to whether.
All right,
That's there.
we'll accept for the time being.
Yes,
Yes,
Then, my lord, these witnesses were examined, madam. Then subsequently you are asked, my
no,
lord,
105, what is 105?
105, my lord, there's a question which I put the.
To a witness,
Prosecuting witnesses.
to a witness.
Witness.
No, we want to know what questions were put to the delinquent officer.
Then, my lord, lordship will see 115, my lord.
150.
15.
So 115, you plead guilty or not, you say that was not put.
Yes, but I say it was not, never asked, my lord. They said it was asked and refused.
So they refused to give any answer.
This is the second stage, madam. This is the second stage. There is, in fact, it should be asked whether he been guilty on the 2 stages.
This is akin to 313.
This is the second stage, where he was, they say, I was asked whether I plead guilty or not. I said,
Are they recorded somewhere? These questions, 115, question and answers are they recorded?
in fact, this is very Hindi, so therefore we find it translated copy. That's where we were doing. Now, my lord, once he, my lord, second time he pleads not guilty, my lord, then he has to be given at least 15 times to file the written, 15 days time to, my lord, file the written statement, which shall be not less than 15 days. And there is nothing on record from which they can show whether that I was given this 15 days time to, my lord, file my written statement. Though they say that these letters were sent to me, I deserted. And these letters were sent to me, my lord, to my home, my lord, to my address. But there is nothing on record to show, my lord, that these were in fact dispatched to me.
How do you dispute or how do you deal with the evidence of the witnesses? Evidence of the witnesses,
Right.
they've all stated that you have committed the offense.
So you can see how these questions are asked to me, they to the witnesses, my lord. All these questions are put in their mouth, my lord, the answers to be elicited, my lord. Then he did this, he did that. They can only say yes or no, my lord. That's for how this entire evidence proceeded. So therefore, the proceeding was conducted in such a manner that the questions are already there before the witnesses, and they have to only answer in affirmative. Therefore, this leading question will play a very dominant role in this.
How else do you propose the departmental inquiry will be conducted? How else?
The questions were, they were supposed to depose on their own matter, not by asking them questions whether this happened, that happened. If they are witnesses to the incident, whether they could have deposed it either way, on their own. Is it necessary that them to be told or prompted that you say, or you have to, do you remember this, do you remember that? It has to be, it has to come, it has to come from their own.
Come to page number 136. This is the statement of Deputy Commandant who is a prosecution witness. He has narrated exactly what is gone.
But before that, he was also asked these questions, man.
Huh?
He was also this prosecution witnesses, man.
Maybe,
They were
but
all examined in that manner, man.
he was also asked, he is the complainant.
He is the complainant, man.
He is the complainant.
All these questions were initially put, man.
Who is Rakesh Rao?
Rakesh Rao was the person who was supposed to be eligible management. He was the person who was eligible.
First part he narrated that is not in question.
Hmm?
The first part of the statement given by Rakesh Rao. That is not in question, there is a narrative for that.
Actually, I didn't see the questions that are put to him using that.
Pursuant to this, did you file an appeal?
Yes, sir. I found it later on, after my appeal.
What was the decision?
It was, it's a kind of order, so there is not application of my business certification. I filed a revision also, that was also. Appeal was dismissed on 21/10/2001, and revision was dismissed on 14/12/2021. But here is a case where constable was standing for them, and they often allowed him or at least asked him the question whether he wanted defenses. Because he was not in a position to participate in the inquiry or defend himself in the inquiry without any defense assistance. And that question often been put to him whether he wanted to avail that position. Given his ranking and the manner in which the inquiry is submitted. Secondly, it was 15 days time was not given to him. At least 15 days time after being given, though they say that this so-called letters were sent to my residence. Nothing has been shown to show to prove that these were actually dispatched. Just merely having some notice in the file that these were sent to me, that is not sufficient. They have to show from the records that I had that these letters were dispatched to me. And it is not as if I did not participate in the proceeding at all.
Where is the appellate authority in order?
Appellate authority order lordship will find at page 38.
P8.
Yes.
This is the appellate authority.
Yes. First, page 30 and 39 raise the charges. Then after completion department inquiry conducted by Commander Swinso, the charges being to the constable as per the dismissal service. They agreed with the state order the constable by the for restricting service. The important grounds are as follows. The appellant and the person discharged in joint charge sheet and a joint inquiry is initiated. As per 37D, for joint inquiry permission is mandated. But without having such permission, the appellant for dismissal service, therefore order of dismissal is issued. On basis of the aforesaid appeals, proceeding filed and on the detailed examination and consideration of the comment given to the disciplinary following findings in the light. In order to maintain discipline in the force, all the equipment attached to the 7th CFP of Doha. When apart from the appellant, the 3 other accused were sentenced 15 months in prison, the people of other offenses on the judicial trial. That the 8th battalion has per order to the swing so that resisted the accused as per section 12 of the CFP Act. Since they were in prison. The appellant was, while he was attached to the 7th Jura, became a deserter. On 24/5/19.
I think the other people must have also come before this court. Kindly read serial number 3 at page 40. 40. All the others, their appeal has also been rejected. So I'm sure they must have come. Anyways, carry on.
As per rule, sorry, the appellant was attached to the 7th Jura on 24/5/99, became a deserter. So in fact, there are different dates of him being a deserter. At different stages, they made statements.
But no proceeding for desertion.
No proceeding for desertion. That's another ground.
Now, at serial number 2, page 40, you were held, the proceeding was held to be ex parte, there is no dispute.
Because I said.
So where were the questions put to you?
Because in the beginning, I paid for 3-4 days. Once the conditions became, I was not even provided food, there were specific statement. I was not even provided food, I was not allowed to sitting statement. So I had to, and I was even threatened in the inquiry.
Where have you stated all that?
Yes, sir. Fantastic.
Now, once he deserted or left or did not participate, what steps did you take to inform him?
We said the proceeding, each and every after taking each and every statement, then a copy to him by the
No, before you took a statement, did you send him a notice to him that we are proceeding with the?
Yes,
Huh?
Yes,
Is it available here in the notice? Has it been received? Has it been received? Has the notice been served at the correct address?
He admitted that he received the charge sheet at his home address at the beginning. Thereafter, take it convenient to that I have not received the dismissal order.
No, that will come later, but the notices pursuant to his non-participation, was it sent?
We have sent by the.
Has it been served or delivered? The correct
Because
address?
they have relied upon some postal receipts, I have replied saying that these are neither my signatures, nor any of my family members.
But then have you having left the your barracks or cantonment, then how will they inform you? Other than by registered post?
So look, that's what I'm saying, the registered post, whichever the acknowledgement cards, those do not contain my signatures or any signature of any of my family members.
What to do? You must send at the correct address in which you received.
So that when we were posing there for assuming that is a center. The question here is whether he was given the time to file the written statement. Because he paragraph 7, page 7, paragraph 17. I have stated that I had to read the proceeding in a state where things were not in a, I was not in a position to continue anymore. With the inquiry, page paragraph 17, but the inquiry was conducted exporting in the petition on the ground, that the petitioner became a deserter during the inquiry. Proceeding. In this context, it is pertinent to mention that the petitioner had to leave the inquiry proceedings under oral threats of dark and dire consequences by the inquiry officer and other vested interests, and in the absence the minimum facility to bear its pudding and lodging. So now he had to leave under these circumstances. In my reply, I was stated that it was threatened that unless you say plead guilty, we will not spare you. We have to prove plead guilty, then we'll see what can be done.
Where is your reply?
My reply to the additional letter.
Not reply, counter affidavit.
Counter affidavit is to my additional letter. Because in the initial affidavit, it was a very it did not indicate many things, but subsequently they filed a detailed affidavit, additional affidavit, to which I replied. And in the earlier affidavit also I replied, but the additional affidavit was more detailed one, so I replied to that. But there is a page 187 running page. Paragraph 5, page 89, 189.
But you'll have to substantiate your moving away from the your place of posting without any application, without anything being reported, nothing.
Difficulty is because he said, hey, what was the issue here? Had a defense system been given, man, perhaps things would be totally different. This is where the.
No. A defense assistant not given, does it mean you'll run away?
No, my.
You are certain, you are not given food, shelter. Could you not have at least brought it to the notice of some authority?
What has happened now? He is the lower rank officer. Perhaps had a defense system given, given proper advice. That's perhaps where the fair play would have come in.
Under the rules, isn't there a provision for counseling? Somewhere I read,
That is not there, counseling.
is it CRPF or BSF, I forgot. Anyways,
Because my case was civilly reduced in the process.
your case is that they asked, you were not allowed to participate, you did not file WS. They asked you leading questions, you were threatened, you were not given food, shelter, you went away.
That are not denying, I went in
Right.
because of the circumstances. And my therefore case should be, our defense system be given. Insurance person different because I would have got a fair opportunity. to
Did
defend
you, was it, you show us that there is a mandate to provide you with a defense
myself.
assistant?
I'll, because it's not there in the rules, but I'll rely on the judgment.
And you belong to a discipline force.
Yes, ma'am, I understand.
So you, is it a case that you deny the episode? Have you denied this
Yes,
episode?
my case, my case, I don't know anything. But that I cannot present it to the inquiry procedure. You only find the appeal after he has been acquitted. That is the serious. That is why that.
He is filed an appeal on that.
The Supreme Court, 1983, 2 SCC 442 Bhagat comes in.
Yes, 19.
The 1983 2 SCC 442 Bhagat. I'm giving a pause.
Okay, you highlight the judgments, whatever you want to submit. Yes.
I'll be relying on few judgments, madam. In fact, I have made a list of those judgments, madam. I just prepared and replace the entire part before lodging.
On what position?
First, madam, my first, madam, is
You
that-
furnish the list, they'll take it out. You furnish the list.
Right.
Right away if you have,
Yes, ma'am. I have.
yes.
In fact, I have copies of the judgments also.
Copy is okay, you can give us, but
Okay.
at least we need the list. Second book was page number 29. এইটা মানুষ একদম এই অনুযায়ী যেটা রিপিটিশন এইটা মানে পেজ নাম্বার 16 সাইড কনস্টেবল the petition commission is a record as in you with the yes. Non-appointment of presenting officer.
But that also the includes that the low rank officials to be given the. Here also no presenting officer is appointed. That's another job.
Is it a universal proposition so far as this particular? Does it relate to CRPF? Does it relate to CRPF? Then
He was not, there's one is on appointment presenting officer. that vitiates the inquiry. That has been dealt with in various judgments, including our High Court. Then, that rule, infraction of rule 27 vitiates the proceeding. Then, low rank officials should be given the offer assistance to a person who can assist him properly. Then, with the appellate authority and revision authority, there is no application of mind. Of course, these are not the CLP proceeding, but they are supposed to apply their mind and if it is not done, that vitiates. And so there are other two judgments with regard to one is that after this judgment of one of our High Court. Then it's a long time ago, we already last. So therefore, there was being some back previous. And the procedure for declaration of disorders that in another case. That
Okay.
so these are the judgments I'm relying upon. My basic case number one is that there was no I was not even the procedure was violated, was not asked to plead guilty or not at first stage. Secondly, my lord,
This is with regard to rule.
27. This is 27C, 27C. No presenting officer was appointed. Therefore, all these questions were asked by the inquiry officer, and that way asked leading questions. I was not provided this 15 days time to provide a written statement. In fact, they may contradict statements. The first affidavit they said, I submitted a written statement. Then later on, they said that I did not submit a written statement. In fact, with regard to my date of desertion, different claims have been made at different points of time.
Then
I have looked at a synopsis of the
okay.
So initially, they took this statement. I had submitted a written statement. I will find a page 5 to affidavit. Yes, page 5. The petitioner deserted on 24/5/99. Then they say I again reported on 10/9/99, and again deserted on 17/9/99. And I had submitted a written statement 12/9/99. But later on, they say that I did not participate in the inquiry. I neither submitted neither pleaded guilty nor pleaded not guilty.
What about the latest judgment of the apex court? Members of discipline force.
Well, members of discipline force have to be there's no doubt on that. That will not happen. But then the issue here is whether a person has been properly paid dealt with in the inquiry. Lordship is not going to the other aspect, because lordship mostly confined to the procedural part. That's what the lordship will do in a disciplinary proceeding. But we will see how the procedure is followed. Here, a basic issues which remain. There is nothing on record to show that the person proposed that whether he wanted defense. The defense system was not provided to him. He was put in an unfair process. That's the crux. That's the beginning. All these things, his desertion or his living without proper explanation or proper representation. Perhaps would have been tackled and there's been a written sense. There was no one to fight the case for him. The inquiry officer was not acting as the judge, as the prosecutor. No presenting officer was appointed. So all these factors has to be appreciate the proceeding under the rule 27 of the CFP. And the judgments which are relied upon are basically on with the CFP persons, CFP rules. And as I've stated, their stands are contradictory. And whatever statements they've given with regard to the condition of documents to be filed, I have specifically replied in the reply matter that in an affidavit of reply that the acknowledgement parts which were next to the affidavit reply matter are neither signed by me nor any of my family members. I do not know who signed this documents. And
So you don't, you have not received the inquiry report.
No,
Then how, why did you file an appeal or how did you file an appeal?
in fact, this is my stand that I did not receive anything.
But you filed some appeal.
The page after my acquittal, based on my acquittal, I did it. And why I point out these leading questions, they were these answers to questions in such a manner that the answers were obviously good manner. And thereafter the departmental weaknesses. And by this manner, the inquiry officer was acting as both the prosecutor and the defendant. So the
But
inquiry
you
officer.
nowhere pleaded, did you say anywhere that these allegations are false, not being connected? Not make the statement anywhere in the petition. Procedure is one aspect.
Yes.
Now, if you are guilty of the alleged violence, alleged offences, acquittal, is it an acquittal or discharge?
Acquittal.
It's an acquittal. Where is that order?
That order will. My lord, page 29 of the report. In fact, they could not adduce any evidence whatsoever. One of the allegations was that there's some damage done to the civil police and the gypsy was broken, was damaged. Page 29, it starts with page.
Don't you have a better copy?
No, this copy is very clear. In fact, initially we approached the Allahabad court matter. There the case was last week filed in the proper court matter. Page 37. In fact, page 36, what you will find. Moreover, in this case, the most material witness is Assistant Commandant Rakesh Rao, but the prosecution has not examined him. The prosecution has not shown any reason as to why he failed to examine the material witness. No examination of material witness would lead to the presumption that he would have been examined if he had not supported the prosecution case. Considering the above facts and circumstances in the record, I find that the prosecution has failed to prove the case against the accused persons beyond all reasonable doubt. Therefore, the accused persons are acquitted and set at liberty. And in fact, the points of determination also find in page 32. Whether the accused persons in furtherance of their common intention committed house trespass and illegally entered into the residential quarter of Jawan Assistant Commander, Mr. Rakesh Rao. 2. Whether the accused persons in furtherance of their common intention used criminal force on Jawan's Assistant Commander, Mr. Rakesh Rao, execution his duty as a public servant. When the accused persons in furtherance of
Okay,
common
but
intention.
the acquittal, does it require any departmental proceeding or is it necessary?
Edit comes before things will be different.
May not have been.
Because then they couldn't have prosecuted me without the further approval. But since it came earlier, the departmental proceeding was completed earlier. And that's the reason I filed the appeal afterwards. When the accused person furthers a common intention by damaging the vehicle of Morigao police station. So all these are similar charges. All the charges are similar, though they are trying to say the charges are different.
All right.
On those charges, whether the criminal proceeding was initiated, and their material witness even did not go to use any evidence.
Okay. Anything else?
Well, that is for the. In fact,
Yes.
when they say the inquiry report was given to me, my lord, and my lord, the inquiry report, my lord, was purportedly, according to them, my lord, sent on 4/11/2019. My lord, I have denied, my lord, receiving, my lord, even then, my lord, assuming, my lord, it was sent on 4/11/19. And my lord, on 19/11/19, my lord, the dismissal order was passed. That is on the 15th day itself. So my lord, they have presumed, my lord, that the registered post letter, which was sent on 4/11/19, would have reached me on the same day, and I would have replied in 15 days, my lord, and they without waiting for any day further, my lord, they proceeded with pass this order, my lord, on the 15th day itself. Thereby clearly showing, my lord, that they were having a preoccupied mind, or my lord, they were already have made up their mind to not dismiss criminal service. They did not wait even day longer, my lord. 4/9, they said they posted it, my lord, on 19/9, that is exactly on the 15th day, my lord, they passed an order, my lord, dismissal matter from service.
All right.
And I would note, my lord, almost taking the points of this.
We have received. Yes.
Lordship knows that in the department of policy finding with facts under is very limited lordship. Lordship, first of all, he has not denied that whatever has been alleged he has not happened or he has not committed.
You did not even put that question to him. Is required under rule 27.
Because he did not participate in the his plan.
No,
Lordship,
the first time.
Lordship, can kindly note the date. Date of incident was 4/8/98. He was placed under suspension on 7/8/98, Lordship. Then on 24/5/99, he left this place, Lordship.
Why
Then
did
he
you- why
reported
did you-
again on 10/9/99.
Why did you allow him to leave the place?
Lordship, he himself led our lordship from the. Then he reported again on 17/9/99. Then as he was absent, we completed the inquiry proceeding and submitted the report on 2/11/99. And it was sent to him on 4/11/1999. Okay. And then thereafter was the dismissal order on 19/11/99.
What is the name of the petitioner? Rajpal.
Now, Lordship, can we take Lordship, the affidavit which you find annexing all the proceeding of the departmental proceeding. Lordship, can we come to page annex C? Maybe Lordship, the departmental proceeding, Lordship, order against so and so, by commanded under so and so, for order of the commanded memorandum annex 1. Annex 2, Annex 3, Annex were sent to the number so and so Rajpal Pro register post by commanded so and so. Thereafter, a copy of the commanded number so and so for appointment of inquiry officer, memorandum charges, and was sent for register post on home address of Constable G.B. Rajpal Singh. Village so and so, so and so. Apart from that, 15 days time was given to the benefit when sending register letter 21/8/99 to home address of so and so. That's what we appeared before the inquiry page 3/7/1999. And according to the Rajpal reported on Vadrova on 10/9/99.
Now under rule 27, you are supposed to ask him certain questions. Where have you done it?
Cosmic come to play in the next page 1999. Rajpal so and so, officer so and so, memorandum annex 153 was sent to your home address by commandant through register post and so and so, so and so. Apart from this, copy of which order of appointment of inquiry was also sent to you through register post. Have you got above letters and orders? Yes, sir. All appointments and documents have been received by me. So, posing for a moment, all this sent by register post is home address he received. And thereafter, he said, make it think that the inquiry report and the dismissal order and not received, which was sent at the same address. The next question of all copies of order Commandant so related to departmental inquiry against you, including memorandum of charges, annexure 1, 2, 3, 4, order regarding appointment of eligibility, etc. have been given and made to understand in the language. You understand when each and everything written in above order, yes, sir, which you have read and tried to make me understand. So he is admit all those things, Lordship. The next Lordship.
He doesn't admit, he understands. He doesn't admit, he understands.
Lordship. Now, Lordship, as regards to the question which has been raised now, Lordship. राजपाल क्या आप आपने विरोध लगाए गए उल्लिखित आरोप हेतु स्वयं को मानते हैं, आप निर्दोष मानते हैं या आप निर्दोष मानते हैं? तो अभियुक्त नंबर सो राजपाल सिंह ने किसी भी प्रकार का उत्तर देने से इनकार कर दिया.
That is a gist of the questions asked. In page 104, these are specific questions you have put to the delinquent officer. The question among. Huh? No, then what are these questions?
Yeah, we are asking whether he feels guilty or not.
In your gist, you say he refuses to answer everything.
No.
But in 104, he has answered.
Yes, 104 is but the particular,
Then
but the particular question whether he feels guilty or not, that he has not answered.
no, you.
Lordship, whether he has been prejudiced for that. His only allegation is procedural lapses, Lordship. Whether that could have improved his case, Lordship. Had he denied anywhere that
115 is the gist of the questions asked.
Lordship, referring annexure
Annexure 5, Annexure F.
F. This Lordship.
Annexure F is this is the gist of the questions asked. Now, why these questions 1, 2, 3, 4 at page 104 are not a part of the gist?
Part of the
Gist. 104, you have asked him 4 questions. This does not appear to be a part of the gist. Which means 104 was asked on some separate day, separate occasion. And 115 was asked subsequently.
No, not the record is written on the same date, 15/9/99.
It is 12/9, 104. The date shown is 12/9.
Then the next executive date also. The continuation there. The dates of the.
Gist is 15/9, but the questions at 104 is on 12/9. What I'm asking you is in 109, but 104.
Yes, Lordship, there is a proceeding on 12/9/99.
So 12/9 perhaps is the opening day of the proceeding.
Opening day, Lordship.
So ordinarily you have to ask him on the opening day whether you plead guilty or not to the
That is
allegation.
not necessary, that is also not mandated by law, Lordship, that it has to be
That is what the rule
on the
says.
very first day, Lordship.
No, not on the first day, but the rules mandate. And you have given the gist. 10115 is the gist.
27/1/2 says that the commencement is required.
Is there a specific provision here for appointment of a presenting officer or
No, Lordship,
It's not there.
that is not there.
that is not there?
That also that.
But there are judgments where it says that presenting officer is to be appointed.
I think that, Lordship. Yeah, yes, to so much, you didn't use him for because of that, any infraction of law.
That is a procedure, if it is an established procedure of law, that you have to appoint a presenting
That
officer.
is not mandated by the CRPF.
So you have to distinguish the
Act
judgments.
or law.
You have to distinguish the judgments.
Pardon?
He has relied on the judgments. There are judgments to show that non-appointment of presenting officer is fatal. You have to show us that it is not applicable to CRPF.
Give me some time to go through that judgment and coming to concur to that.
Depending on what the lawyer pointed out, well, it is saying that inquiring not the inquiry is not saying everything. He is responding to every question. What happens in between these folks responding to it? That's not because that shows whether that it was not as if he came in mind that will not cooperate with the inquiry.
Now those information are not here with you, not here in the record. So as on date, there's no point trying to.
No, but I just that's what I'm saying that the record is there. On one day, whether he is answering every question, man. Suddenly, whether it changes, man. He did not come to the inquiry, whether and it is the intention not to participate in the inquiry, man. To that, whether simply to the day one, whether you have not said, I don't understand anything, I do not understand anything.
Okay, our learned counsels for the parties, the petition pertains to the challenge of the dismissal order. As well as the inquiry proceedings and the officer order of the appellate authority. Whereby the petitioner was dismissed, you are dismissed from the services as a constable of the CRPF. So the petitioner has challenged his proceedings on various grounds. The matter has been heard at some length. Learned counsel for the petitioner has concluded his arguments. Respondent counsel would like to respond to the judgments relied upon by the learned counsel and the petitioner. List again on (22) की बात है। We'll keep it on 22, subject to 22nd. 22nd August.
Some difficult, 89.
29 also. 29 also. Some matters are fixed. Then it goes to 31st. 31st.
Okay, let me 22nd level because he will be replying on the that's still and takes some short.
29. Sorry, 22nd. 22nd. List on 22nd. Let's get over there.
Item number 27.
Charges against the environment of charges at the 18 members and
18.
11% and place 20.
Yes.
4 charges were raised. Your charge number 1, court number 24. Dear Kapoor is posted in the industrial sector in Rizal. Check on 29/8/2009 is around 450 hours without any special result. It created an atmosphere of disturbance and abuse court number 24. The box left his state and raised court and Sanjit Travel 47 issued for DP and pointed it at his head. This act of so Dear Kapoor should take conduct irresponsible behavior and indiscipline and also excessive criminal nature.
Next charge, my lord, who AN Kapur will posted in the industrial sector in ASF in Gujarat. That on 29/2008, around 12 hours, he left his post at his tank from backside watchtower without the permission of the superior officials and without handing in the service rifle AK-47 so issued to him for duty and which the purpose of influencing the department came in his official residence. And locked himself in the vehicle. This behavior of a member of an armed forces show great indiscipline, misconduct and irresponsibility. Third, three, JN Kapoor, who is posted in the industrial sector in CSF unit for Buddhism at around 12 hours. The young unit BHM HPC ordered him to come out of his quarters and surrender the weapon immediately. He threatened to fire at them. This act of so based in discipline, behavior and state misconduct and also disciplinary. Next one is my lord, JN Kapoor, who is posted in the industrial sector in KSF religion. The during his 7 years of service, he has committed an act of indiscipline and misconduct and got 6 punishment and along with having a bad service record, he has acquired the incorrigible habit of repeating indiscipline, misconduct, irresponsibility and ignoring lawful orders. Out of 6 punishments were 5 for quarreling, dereliction of duty and irresponsible behavior. For this charge, my lord, he has already undergone punishment during the period. So this is my lord.
So the inquiry report wanted him to
Take my lord.
punishment under some rule
Yes,
of CIC.
yes, 36. Rule 36, my lord, inquiry was conducted.
No, where is the inquiry report?
Page, my lord, inquiry report starts with page 26. Starts 26. Inquiry officer was appointed. Then, my lord, charges were, my lord, informed. Then, page 28, my lord, charges admission or denial, my lord, during preliminary hearing conducted on 12th. The delinquent has denied the charges leveled against him and that he could not collect the same because on that day his mental condition was not fit. Accordingly, my lord, this is put with my lord. Defense statement, my lord. Then page 28. Page 28 down below. That the delinquent post number 72 JN Kapoor under suspension injustice sector ASF all together of his statement of defense has stated that he cannot say about the charges leveled against him due to his mental disorder and presently he has recovered. Support of his defense. The delinquent has submitted the medical papers by the executive against the queries put by the inquiry officer. The delinquent submitted the medical bills and reports by serial number 1 to 10, but he did not submit the detailed report and prescription given by the specialist doctor. And on being asked to submit the same, he replied that he has been submitting the same and would submit later. But the delinquent has not submitted the last medical certificate. Then, my lord, regarding production of defense witnesses, he denied, my lord. Then description about presenting officer, my lord. Then objection, admission by the delinquent regarding appointment of inquiry officer not done, my lord. Yes, he agreed to the inquiry officer, my lord. Defense resistance, he denied, my lord. Then presenting officer's brief, my lord. From where we find out everything, my lord. What is my lord? Facts of the case. The presenting officer has prepared his report on 14/2009. And having gone through the statement of PWD and PWD, as well as the documents regarding his illness, right? Exhibit so. The presenting officer has stated that on 29/2008, from 2 hours to 12 hours, post number so JN Kapoor was entrusted with his duty in the industrial sector bedside of first hour.
So what was the conclusion of the
My lord,
inquiry officer?
all the 4 charges were put.
So what was recommended?
And my lord, one thing I
No, what was recommended?
recommended for my lord, delivery from service.
Where is that?
That is my lord. Page 54.
Where is it?
My lord, page 54, sir, my lord, we have not recommended anything, my lord, he has submitted the inquiry report.
Ah.
From the discussion made above and from the statement and document submitted by the prosecution so we established that the post number so VN Kapoor during his 8 years of service acquired fixed penalty for distributing further misconduct and the third
Then what happened after these inquiry reports?
inquiry report and he was removed to the service, my lord, that is page page 80, my lord. B5, and it's a B5.
Hmm.
25, order dated 26/3/2009, my lord. He was removed. Last week. And yeah, before that, my lord, he has filed a representation before the my lord disciplinary authority. That is at page 71. That explains his position, right? Page 71. Page 71.
Page
71. His representation. It's a long representation. May I read it, ma'am? P4. And it's a P4.
1 minute.
Inquiry officer has not considered the document submitted before it as medical minor certificates from the minor medical hospital of Sujajan Oil as well as the AMCH minor Durgi Government. He was in hospital for minor more than a month for his mental condition. He was treated there. That documents were never considered by the inquiry officer. But in the inquiry report, it is revealed that he has submitted the minor medical reports before the inquiry officer. That is yes, page 36 down below. He has submitted the document, description of document, medical document. Page 36 and page 37. These documents were not considered by him. We before the minor's inquiry officer is that pilot about the incident is concerned, he is not in a position to recollect all these things. Because on that day he was not in a position to accept because of his mental health condition. Immediately on the same day, he was admitted to the Malad hospital at Duryadan, and thereafter he was referred to Assam Medical College and Hospital. Malad. He was treated there for more than 1 month. Major punishment.
Now, on what ground are you challenging it?
I don't.
What is your ground of challenge?
Ground of challenge is I don't. The disciplinary inquiry officer as well as the disciplinary authority, affiliate authority and divisional authority have not considered the fact that on that day he was not fit, mentally fit.
Where is that certificate?
Certificate, my lord. I have my lord in the inquiry report. Lordship candidate comes to page 36.
36.
Page 30.
Yes.
Down below. During inquiry, this is the inquiry. During inquiry, the delinquent has submitted the following medical testimonials. Photocopy of the referral letter dated 21/9/2008 of the well referring constable so to AMC Division. Then in the next page, in this document, there is mention of referring the constable J.R. Kapoor to AMC Division for advanced treatment.
So where are the documents here? Have we produced it?
Then documents are there in my level.
Just let us have a look at these documents.
174 onwards.
174, Office of Superintendent, Ranchi.
This is of 2010
Madam, next page, my lord, next page, madam.
When was the incident?
My lord, also kindly see page 175.
2008, so it's from 2008 also.
This is the document by which he was treated in, my lord, Disciplinary Medical College. After treatment, he was released from the hospital. In Disha 30. Page 70, 170. Resident physician, Department of Psychiatry, Assam Medical College and Hospital, Dipigor. Then assistant professor is also there. Next page, my lord.
What is F23? Disease?
Next page, there. It is only, my lord, in the inquiry, it is that you are suffering from philia, my lord.
Even jaundice one.
Philia.
What?
In the inquiry report, page 32. The inquiry officer had mentioned that you are suffering delinquent therapy, suffering from philia in last 1 year, and earlier too, he had no mental. He has referred to that.
This certificate was issued on which date?
This certificate was discharged, this is the discharge certificate.
On 2005? No, 2009, 8, 410.
410.
And the date of the incident?
28.
28.
Date of discharge 410.
What is that page 176?
This is the document by which my lord was referred to my lord and the date of incident.
There is something written there, there is no significant.
There is no significant present history of mental illness.
Then second,
No.
referred to Assam Medical College and Hospital, Psychiatry Department
No.
for further management. Advice, my lord. Okay, thank you.
He was referred to?
My lord, Assam Medical College and Hospital. Advice, my lord, right column.
Right column.
Page 177.
Oh, 177.
177.
175 prior to 175.
Yes.
Also it is,
This is the document by which my lord was referred to AMC.
So AMCS, he was admitted on 22/9.
Yes, sir.
You were referred on 21/9.
21, my lord,
21/9 you were referred.
Yes,
22/9 you were admitted.
yes, sir.
410 you were discharged. And the opinion is that there is no significant past.
Past.
What is that?
Present, my lord, 60.
Oh.
he,
Past or present history of mental illness.
he is suffering from jaundice in the right hand side of.
Suffering from jaundice.
Suffered
For the
from
purpose of jaundice. For the purpose,
Why
my lord,
was
for the purpose of jaundice, he was admitted in a psychiatry department. my lord.
psychiatric department because
So that is because you were referred from Duliajan. You were referred from Duliajan
That is why.
by a
He was
doctor.
treated there, my lord. After, my lord, department was, student after, my lord, reference, my lord, the emergency doctor examine and then admit, my lord. In the concerned department. He was treated there for long time.
No, not long.
My lord, for, my lord, from 22/9/2008 to 4/10/2008.
where
2008,
Yes, ma'am.
that is about what, 10, 12 days.
10, 12 days.
Then that 10, 12 days is not long treatment.
As a induced patient, my lord.
No, of course, indoor patient. But then the report is that there is no past history or present history. I think it is present history. Significant.
Significant.
Then what is the second line? No,
no insanity.
no insanity. Then
page 179. With the certificate from the Assam Medical College.
Yes.
That we have recovered satisfactorily from the left, and in my opinion, we feel to be good with our normal duty.
1 minute. What is the third line?
Third line is
That 176. After no insanity history. Can you decipher?
First and third four is well and three more weeks. But the second and fourth.
Already. Whatever it is. Yes.
then page 179. Class 4, my lord. Certificate was issued. And which speaks about his fitness to join his pension. And the remaining documents here, my lord. Produce before the inquiry of that. Effective from page 37. What are the documents? Page 36. Page 36 and 37, page 37. These documents are not considered by the inquiry.
Where is your written statement?
Written statement, my lord. Sir, inquiry. That file represented on page 71. Can I accept these photos? Mary. With due respect to some information, I beg to refer your memorandum dated 2nd of March 2009. In this connection, note respectfully, I beg to state that the following purpose of this kind consideration and further superable order that I am innocent and the legal against me are not true. That at the given point of time I am suffering from mental disease, and as such I do not clearly know as to what happened at that point of time. That before proceeding to believe in passport inquiry report and findings, there has been arrived at by the inquiry of that. I would like to respectfully submit that as per the position of content in section 54 of the Indian Penal Code, nothing is an offense which is done by a person who at the time of doing by reason of unsoundness of mind, which is capable of knowing the nature of the act, what that he is doing, what is either wrong or contrary to law. In view of that provision, I respectfully submit that the purported memorandum of charges and also purported findings declared by the inquiry that is actually they are wrong. Then that in view of the provision contained in the person with the equal protection of rights and full participation act 1995, along with rules 1996 and National Trust of Welfare of Persons with Disabilities act 1990, the purported proceedings is not maintained. That in view of the provision context in the mental health act 1987, I would not have seen the purported memorandum of charges as my mental condition further aggravated because of the memorandum containing 4 articles of charges, prosecution witnesses, a number of activities which are examined in the report of inquiry. The inquiry is that proceeded on the basis of surmise and conjecture that at the relevant point of time I was not suffering from mental depression. The inquiry officer has relied upon the evidences of various personnel who have no knowledge in the medical science. The inquiry officer has considered relevant evidences. The relevant evidences is the evidence from the doctor. Just before the proceeding to conduct the inquiry officer has not explained the chart. So the allegations were agreed and the chart including the calamity which can be improved if the chart is good and chart requirement has not been fulfilled. The inquiry officer has
But there There is no medical document to certify that you are
My lord, that is
suffering
also kindly please start with them. Kindly please start this.
37.
Of the employer.
Yes. Where are two?
Start from page 36. Photocopy of referral letter dated 0.4 of the Royal Hospital referring Constable D.N. Kapoor to MCS Road. Then in this document, there is mention of referring the Constable D.N. Kapoor to MCS Road for.
No, but these documents do not certify that you are suffering from mental illness.
But there are other documents.
That is what I am asking you. Where is that? To show that you are, there is a medical opinion that you are suffering from mental illness. This is the defense you have taken. Mental illness has to be certified by a medical professional. Duliajan has referred, AMC has given some, kept you for 12 days and released you, discharged you. What else do we have?
And in another ground, I have argued that my lord, property punishment of removals is a major punishment. That can be my lord order into a punishment.
For the offences alleged, it appears to be a grave allegation.
Property charge number 4 is concerned that already he has undergone the, my lord, punishment with regards to charge 4. And other 3 charges are the same charge out of the same incident. Other charges. In which my lord, what happened, and from that day, it is revealed from the report that there is a quarrel between a constable and him, who my lord said something about his wife. And he has not my lord done anything, my lord. He entered into the room, he locked the room. That is his my lord, what he has done.
You pointed the service rifle at his chest after assaulting him.
Yes.
Charge number 1.
Yeah. There is a my lord provide for some minor punishment also. That would have been my lord imposed on dealing with them.
All right. If you want, you can give a short synopsis or any judgments. Are you relying on any judgments?
I'll rely from that. I'll punish.
No. There is some. When will you furnish?
My lord, today I have given.
But you are not relying then. Giving it is different.
Right.
If you want to rely, you have to rely.
I'll be relying on. Hello, 1995. 6 years, 15. 1995, 6 years, 15. Maybe 749.
What is the party name? What is the party name?
Party name, my lord, DC Chotu.
Paragraph.
Paragraph 22, 23, and 24.
For what proposition?
12, 13, 22, 23, 24, and 26. About my lord, the my lord, power of the court to reduce the border pathway in my lord department.
Yes.
Then about a year 1986 to report 515. As relied upon paragraph 76, 77, 78, and 79. Regarding my lord disproportionate punishment.
What is the name of the party?
That is both Chinnappa Reddy.
For Chinappa Reddy, efficient and yes, Venkatalamani. Done.
I'm asking you the party name.
Yes.
Okay, this is for what, which proposition?
Disproportionate punishment.
Disproportionate punishment.
I will rely on you.
Yes, then. These two, okay. Yes,
The process matter, he has filed appeal before the matter, that is rejected matter, appeal before the DLT, then matter the revision before the IT, for the.
yes,
Lordship, firstly, Lordship, already Lordship had gone through the first Lordship, there is no procedure in there. All the rules and acts have been followed, Lordship, he has nowhere taken their stand also, Lordship, it's a very memorandum of charge has taken that all the opportunities were given to the petitioner, Lordship. Now, what is his pleaded case is that he has taken the exception of section 84, Lordship. So section 84, to get the benefit of exception of section 84, one has to give such a valid and cogent document to prove his mental illness. Even in criminal procedure or Lordship, even in for a criminal case also, Lordship, one accused where it has to be proved beyond reasonable doubt by the prosecution. Then also, Lordship, he has to give a valid and cogent document to prove. And here he had totally failed to show that he is suffering from any mental illness at that time. His petitioner is admitted at the Tuliadan Oyo Hospital immediately because after the incident, this is the procedure they were admitted. Subsequently, to see his condition, he was sent to AMCS, Lordship. But the finding is that he is suffering from jaundice, Lordship, no mental illness. He has one document to show that he was admitted, but that was of 2010, Lordship, and the incident is of 2008, Lordship. And the medical bills, Lordship, definitely medical bills will be there, Lordship, because the prescription shows that he has prescribed medicine for his jaundice, Lordship. So definitely, what bill? Bill means medical bill for that medicine also, Lordship. It doesn't say that medical bill for his psychiatric problem, Lordship. And thirdly, Lordship, he had now taken the plea of Lordship disproportionate of his punishment, Lordship, but that is not his plea in any way in his whole case, Lordship, neither in his representation nor in his repetition. He is on
what plea?
plea of disproportionate
Punishment.
punishment, Lordship. That is not his stand in his representation nor in his repetition, Lordship. And seeing the offences all are proved, Lordship, and the punishment is very much proportionate, Lordship. He had showed the rifle to the other persons, Lordship, and anything could have happened, Lordship, if he could not have been resist at that moment, Lordship. So in my humble opinion, Lordship, there is no fault from any corner by the disciplinary authority, and it's a very fair disciplinary proceeding, Lordship. And after considering everything, Lordship, we had given all opportunity to him to even ask him to submit his medical bills, etc., Lordship, which he said his reply is that he forgot or he don't have. So that plea that section 84, it doesn't come here, Lordship. It's not a case to be considered under section 84 exception, Lordship.
All right.
That's my humble opinion.
Regarding this matter, punishment matter, paragraph 26, I have my. Paragraph 26. Regarding submission of my friend and matter, I am not treated anywhere. That is in their paragraph 26.
And Lordship had already stated that the recent bail of
Paragraph
26.
26. Do you have that judgment?
Lordship, I can. Give the judgment of C or A, one Prasad Lordship. It's in, I can send it by mail Lordship.
You can send it to the
Yes,
court master.
Yes.
All right. Had reserved.
Item number 28.
Take a look at it. Pass over for the.
There is one issue, respondents 1 and 2. They are represented now by the standing also the eligibility. The names are.
Isn't when it is called up, you make. Place it.
This one is going to start around 59.
We are passing it over for the day at your request. You want to argue today, we are open to hear you.
10 minutes if possible.
10 minutes, we don't know if it is possible. We will keep it aside for the time being, you see.
29.
In this case, the divisional code procedure is available in my petition. And regarding the single judge also I applied for it, but unfortunately, it was number in 2007 and actually wrong copy has come. People worship that.
Which year is the judgment? Which year is the judgment?
Judgment was 6/12/2007. Okay, bill number 6252 of 5297 of 2005.
What is your prayer here?
There is the prayer worship. Responsibility forward the name of the private respondent of 5 for promotion to the post of seniority. Although I am the senior most.
You have retired.
I retired.
Ah.
Filing. And in this case, well, since I joined in the district establishment, whole vacancy regarding joining in the district establishment. And responsible 5 initially joined at half. Subsequently, he came.
When is your claim for promotion?
That losses. Claim promotion losses after guidelines prepared by the authority losses. The guidelines is that losses paid. Page 20, this speaking order.
Please,
Page 23.
22.
23, and the judgment of this honorable court losses, division bench judgment, page 16.
Division benches for what purpose?
Regarding the earlier losses, there are promotions are made from the state-wise cadre. It was challenged. And this honorable court allowed the requisitions and subpoenas are gone by their division bench losses. That any promotion to be made from the district wise cadre. And on that basis, guidelines have been prepared for it. The speaking order passed.
Where is the order of the respondents, private respondent?
The gradation list, prepared losses. The gradation list is page 34. Her name placed at serial number 1. My name is shown serial number 2.
Then
Page 34.
what is the mode of promotion?
Mode of promotion seniority come merit.
Ah,
I am the senior on the basis of guidelines losses that promotion to be made from the district wise seniority, the date of joining the district. Here is the case with one of my joined initially at half. That's part on our own this year. That's why he junior privilege. The guidelines that really say from the district wise seniority from the date of.
where are the guidelines?
Yes, That guidelines is the page 23, Lordship. Speaking order, Lordship, page 23. Okay, guidelines for promotion, page 27.
The speaking order is passed on
On the basis of the judgment of this honorable court, Lordship.
division bench.
Division,
What was the direction of the division bench?
division, direction of this. On the basis of direction of improvement of that is page 16. The relevant portion starts from page 17, Lordship.
The appeal was dismissed.
Appeal referred by the state that was dismissed. And on that basis, Lordship, guideline was secured. Order passed on 28/4/2016, page 20. May I read, Lordship?
What do you want to read?
So regarding Lordship,
You read the division bench order,
Lordship,
page number 17.
page number 17 is the division bench order.
Yeah, please read this order.
From second paragraph, the dispute in this case arise out of two parallel rules relating to recruitment and promotion of ministerial staff in agriculture departments, rate the services ministerial staff are treated as district-wise cadre as per 1967 rules. The 1973 rules declare the director of agriculture as head of the department. In this case, the director of agriculture considers the employee of the posts like LPA and EBA as stage-wise cadre and granted promotion and directorship from amongst the LPA and EBA. The all Assam ministerial officers represent to consist of employees from different departments by the institution number 1 for devotional post chapter 23 or the ministerial staff of grade 3 should be a district-wise cadre and should not be treated as stage-wise cadre for promotion. The department argued before the learned signature as per 1973 rules. The head of the department should be the director of agriculture and he is the proper person to get promotion. The learned signature consider the rival consensus and the even in fighting of the government made the following resolution and devoting the constitution to the party. After voting through the provisions of Article 1970 is clear that the resistance to the post of Serbian in the agriculture is to be made for separate and the promotion of the post of BPS are exclusively made in conformance to the provisions of Article 1973.
Now, where are the 73 rules? 1973 rules, where are they?
On the director's 1973 rule, first, on the base of lordship, in that time there is no article regarding the fishery department.
No. There is a finding of the division bench
Yes, Lordship.
that 1973 rules are there. What are these rules called?
Assam Directorate established the Minister Service Rules 1973. And then there's an interpret that used to be, it requires to be district wise.
No, so where is the division bench stated? Which paragraph?
Lordship, paragraph 30, page 18. Before partnering with this case, it is observed that this court cannot issue metamorph for making promotion. However, it goes without saying that the government being a model employer has also to see that for the purpose of considering and protecting the legal rights for the non-part for the position of executor for being considered promotion. That is required that no list may be prepared. And from that, among the senior most eligible persons may be considered for promotion. to the post of DPS, we will use their experience and services for considerable years in the party. The state agreed by the state government filed with the bill on going through the reasons given by the learned secretary. We find that the based on the ministerial staff of the duty for the district level could be treated as district level grade. As per the handbook of the for particular and this split, the learned secretary has taken proper to interpret the general circular in the context of the provisions of the rules and.
Where is the judgment of the learned civil judge?
And that's not the applied for. Because that available, but unfortunately, while putting the number, we are given +7 instead of 2005. And people lost it, 3 days time may be allowed.
Which year is it?
That judgment is lost in the year of 2007 lost it. This still 7, application number 5297 of 2005.
You produce the judgment. Learned, do you have the copy of the judgment? Huh? No?
I may forget one aspect. Terrorists put their prayer. Petition under opinion, factual.
He is retired. He is retired. He wants the financial benefits. So that you'll have to find out whether he was entitled or not. If yes, then you'll have to hold the.
All around seniority. The petition. If document and come to matter of
In this. District wise not, yeah, the guidelines say district wise.
So for that, we need to see the rule. What is the manner of promotion? You are appointed under what, 2 different districts? Where were you appointed?
No, same.
No. Initially, she was appointed in Amalgamation.
Yeah, but he was transferred from Aplum to Kasar.
Ah,
And public interest. So my lord. Not on own.
so what you are saying, what is your submission?
Official lawship, as per rule lawships. The guideline is.
Normally, there is no inter-district transfer.
Where is it?
There is.
In case of mine, yes, inter-district transfer, but in my case, my lord, I was transferred on public.
Where is the case? It rule frame as per district wise. But yes, earlier it was as per state wise. If state wise could have been taken because then is senior.
No, I am not getting you. Sorry.
Earlier lordship promotions are.
What
made.
was decided by the single judge?
Single judge decided that district wise promotion to be made. In the district.
So how is the promotion now made?
That in the district, the. The 5 things have been forwarded.
She has been transferred to the district.
That's what to my district.
Uh,
At least their rule said that those who are senior in the district. In the
so
district,
what will happen to a seniority? If she is transferred on public interest, what will happen to a seniority?
But here is the case, she got transfer on her own request.
It's very much clear. The lordship may kindly come to my executive.
First
Do you have the order of transfer?
lordship,
Transfer order,
lordship kindly.
page number,
Page number 10 of my executive.
page number 10.
So my learned lordship, I am taking the guidelines, what guidelines said lordship.
You couldn't place the order of the learned single judge. You were supposed to apply.
Yes, lordship, I applied lordship, unfortunately, take year of the. Lordship mentioned the.
Your whole case is based on the order of the learned single judge.
So lordship, I prayed 3 days time given to me lordship, on maybe taken over 8th of.
Where is that order? Transfer order
Page 10.
Page 10. of See, if you come for hearing, you must ensure the continuous pagination. Please ensure that continuous pagination. Don't say page 10. Page 10 will look into continuous pagination.
Lordship may be taken over on 17th of August.
Wait. Let us go through page 10 first. Page 10 of
Affidavit.
whose affidavit?
Respondent number 5.
What is the name?
Nandita.
Page 10. Yes.
But here is, was clearly in the interest of public service, the following early assistant of the district officer hereby transferred and posted in the same capacity in the case as shown against their name until further.
Why do you say own interest, own request?
Here in the lordship does not say carry out the TA or TA. In the public interest, there has to be TA or TA. There is not. If it is public interest, there has to be SPR. We can take for TA or TA.
This is not a case of singular transfer. There has been yes 4 persons transferred. You are saying that all these 4 are on the basis of own interest, own request.
Even the guidelines say this. May I read the short line guidelines, page 29.
Page 29 of
Lead petition.
yes.
Third paragraph lordship. After this period, then next for PPR. Lordship body. PPR a provisional generation list of each category, seniority and division, they put, considering seniority, date of joining in service under the district lordship.
We get it under the district, but once a person is transferred to the district, what will happen to the seniority? What has happened to the seniority?
Here is the case lordship that has to be clarified even.
By whom? When was she transferred? When was she transferred?
It as part lordship 23, 1292.
What does the rule say? Rules. Ministry.
Some directorate established minister service to Rule 4, 9.
When did you retire?
I retired on
31/2/2018.
1/3/2022.
Seniority come merit only. Criteria is seniority come merit.
We have not been that regarding earlier seniority also. Even that you have visit the guidelines only this require seniority.
I'm carrying on the same thing, nothing. Hard learned councils for the parties. Disposed.
When you buy the unemployed work for
Nothing.
that
Nothing.
period may kind of
Sorry? What is to be considered?
logics. This honorable court initially by keeping notice that definitely mistake.
We have not been able to project anything. Everything is on.
Rule says lordship.
The rule says district, we don't disagree with that, but what happens to a person who gets transferred? What will happen to the seniority?
That plea there has not pleaded lordship that my seniority has to be counted.
That there need not be pleaded, this is what the department has held. Department has taken that seniority because she is senior.
Therefore, take of joining the district, take of coming to post the guidelines, not state that.
These are guidelines. You can't override the rules.
Take of joining in the district laws.
You have not pleaded a case, you have not pleaded a case that inter-district transfer is not permissible under the rules, is it? Is that your case?
Yeah, is the case. We got as far on our own.
That is a submission without any basis.
I think.
All right, we'll pass orders, this was disposed of.
I
Yes.
think 28.
28.
May I please? One of the petitioner before my lord was a sub-register. He was placed under suspension on 15/3/2008. Subsequently reinstated. On 19/9/2008, a SOPOS was issued, page 19. My lord would find therein the charges. The charge is, my lord, single charge. That while you were serving as sub-register party, you have allegedly registered the following land sale deed involving quantum of land measuring 7 bigger 1 kara, 10 lesser belonging to so and so. So these are the registering done. As per government approved zonal value table issued by memo number 5/12/2003, the village Silpugri falls under the zone and tagged at 5 lakhs per kata of land. The location of the scheduled land stands within 1 kilometer radius of Silpugri tank, so and so. The difference of rate of undervaluation stands at 4 lakhs per kata, resulting in loss of revenue. So, my lord, now the information. As per proviso to 27 is one of the Indian standards. Assam Amendment Act, you should have referred the aforesaid land sale deed to Deputy Commissioner after registering those land sale deeds for taking necessary follow-up action by the Deputy Commissioner as per provisions of Section 27A1 of the aforesaid Act, but you failed to follow the proviso of the aforesaid Act. Thus, you have not only violated the provisions of Section 27A1 of the standard, but your such inaction has also left the, this may not be totally known. But your such inaction has also left the Deputy Commissioner Kamrup Metro with no scope to initiate necessary steps for realization of stamp duty. As admissible by exercising his powers under so and so, due to inaction, the scope of realization of further amount of rupees so and so was kept ineffective. You are therefore charged of violation of 27A1 of the Indian Stamp Act, Assam Amendment. My lord, even before I take my lord to the further proceedings, my lord will have the act. The very charge, my lord, is not sustainable.
Indian Stamp Act.
Indian Stamp Act, Assam Amendment.
Assam.
Now, this my lord will also note that these registrations were made in March 2007. My lord, the red and the green. Underline. So therein it says, if I find 27A1 says that if I find that these have been undervalued, I have to refer it to the Deputy Commissioner. And my lord will see the down below, 5, the green portion. My lord. The Deputy Commissioner has power within a period of 2 years from the date of registration to sumoto take up this issue and proceed further.
So what if you
I
do not find it illegal?
I missed out.
You miss out.
I missed out
Then-
because my stand is, I'll show my lord that the letter
Hmm.
by which my lord the amendment was made to the land value.
So if you miss out, you want to say that beyond the period DC has no power, beyond 2 years,
Beyond 2 years, my lord will not go into it also.
right?
My lord, the allegation is that I made it in March 2007.
Hmm.
My lord will see the show cause notice was issued on 10/9/2008. Within 1 year. So how can you make an allegation like this to me?
No. Whether the amount was recovered or not,
My lord, that is their default, my lord. When it went for mutation, they did not do it. The allegations were leveled against me.
no, what is your,
My lord, my case, simple case
no,
was
what is your
that-
duty in respect of,
that, my lord, that notification.
you have to properly value it, make your scrutiny.
I did not, my lord, when it is presented before me, my lord,
Hmm.
I will only have to say whether it's value. The
Hmm.
value that is there is appropriate and there is no much undervaluation and it is stamped properly. Now, this 5/12/2003,
Hmm.
by which it was enhanced, never reached. It is not a gazette notification. It was a communication, it never reached. And within that second part saying that the deputy commissioner was hands were tied, he could do nothing. My lord will see the time limit given is 2 years.
Why his hands were tied?
Because they say I did not put it up before I did not refer it under 27A1 to the deputy commissioner for realizing the amount, so they could not realize it. But the whole allegation, my lord, is,
But you admit that by oversight, you could not send it to the
No.
PC.
no, my lord, I say, my lord will say that,
Page number 24.
yes, my lord will see 4. My lord will see it, the 4, my lord.
No, first you come to 2.
But yes, that however the alleged commission of the partner was neither deliberate nor motivated but brought out by circumstances beyond his comprehension. Therefore, the omission being a bona fide one may be pleased to be condoned, considering the same as a human error, inasmuch as no government circular fixing the valuation of land as referred to in the show cause letter was ever received by this office. And in the enquiry, there is no finding that I had received this one. This is one matter.
Where is the inquiry?
Lordship, that enquiry report my lord would find at page 32. My lord will see how in the manner they have done it.
All right, perhaps. Satisfied.
430.
Perhaps some other day.
Lordship. And there is other matter, I don't know. 30. My lord, I don't know 20 also. Everything is on record, my lord. Only thing, it's also demand of proceeding. Everything, otherwise the criminal case is over now. I've been acquitted. But I'll not take that plea, my lord. But the materials that are there, that will demolish this. The lordship can have it on any day, this to matter together. The man is also with that. Whenever it's convenient.
You'll find some date.
Lordship.
Yes,
Item 39, my lord. Both party we are given the forward by rejecting by your. Can it be on 17, my lord? After sending also. The second of all last 8, but again gives today, my lord.
you'll have it on 16.
16, my
It
lord.
is covered.
Item 35,
35.
supplement.
Supplement. 16. It's on 16 as submitted by both councils, Mr. So and so, that the matter still is covered by judgment of. Which judgment?
The judgment of division bench, we take it 56,
Rate of 56 of
2018.
2018.
Yes, sir. Forward.
Yes.
Item 30, no, 37, madam. After I was not here, madam. When I prayed for a practicing date, madam, on 22nd of August.
You are not there in the last time.
Yes,
He's a respondent.
Yes.
22nd is not possible. It goes to September.
30, madam.
September.
September, madam.
30.
September,
30.
madam. 5th of September.
30. We can have it on 30. 30. August.
Yes, madam.
Item number 37.
37.
37.
32 and 37. 37 cannot take place.
32, my lord, I got 32 also.
You are mentioning which matter?
37.
37. Yes, then 32.
32, my lord, they put the fixed.
32. 32 will, some date will come.
My lord, item number 36.
This should all go into the part 2 hearing list. 32. It should be there in the monthly list. And if you think it is urgent, you make a mention, we'll take it up. Because otherwise we are unable to go to the part 2 list. Because of these 21, 22, 19 matters.
It's kind enough, indicator item ready to be listed in the next part.
Yes, item 32 to be listed in the part 2 hearing list.
That is good. Item number 36. Yeah, get me the email on it for the.
Item 36 also to be listed in part 2 hearing list.
Also, item number
31 also part 2. Why? Why? Let it be listed, you make a mention as and when.
Not in the part of this.
Why?
Because date is not the plot.
Why do you want it in part 1 list? What is the urgency?
Otherwise, not going to take a lot of time.
It will take a lot of time because we are unable to go to part 2 because of the supplementary hearing list.
In that case, doctor may not give me a time, but not in the part.
My lord, on joint frame, my lord, it is to item number 34. On last copy of my lord, the director has to manage one list of data will prepare that, my lord. 2017 matter, my lord. And the extensively of this matter. My lord, is the-
For par, for par matter,
I'm of present.
for mar.
Yes. My lord, in the meantime, I may hand it over this list of dates, my lord. And the
When is
matter will fix on a particular date, my lord. I humbly submit. 2017 matter.
May I, if it can be taken up on sentence. Because last, this next few.
7th, all right, 7th,
Station.
7th of September.
In the meantime, I want the translation.
Item number 34, 7th, as agreed to by the learned councils with the parties. And
My lord, list of that I may submit, my lord. So that it will be easier next day, my lord.
yes,